morning, good afternoon, everyone. Welcome to our pre-trial conference. I'm assuming that Ms. Adamson, who I'm seeing, is a court reporter that has been brought in. Is that correct, Ms. Adamson? Okay, fantastic. We also have a couple interns who will be joining us as an educational event for them. I believe that's Ms. Weissoff and Mr. Rogers there. There may be some others who join. If you don't recognize the names, they are probably also interns who are joining us. I believe you see James Richard or David Pettyjohn show up, that those are interns. All right, I believe Judge Krause will be joining us momentarily here, so just stay tuned for her.
Thank you.
Thank you.
Good afternoon, everyone.
Afternoon, Your Honor.
Good afternoon.
So it looks like we have a few new faces. I see we have a court reporter that we've brought in for today. So before we get started and go on the record, I do want to let y'all know, in addition to being live streamed, because I'm not in my courtroom today. So I'm this, number one. Number two, I do want to let you know that you have a fairly large courthouse audience because we have a number of legal interns this summer who will be logging on to observe, because they've been getting a steady diet of criminal, but not a whole lot of civil, and certainly not high dollar civil with really, really well qualified good attorneys like we have in this case. So we do have quite an audience for you to show off some of your good lawyering. So I appreciate that, and welcome everyone. And with that, I'm going to go ahead and call the case. Madam Court Reporter, we are here on a pretrial conference in the matter of David Bible and Brian Rogers versus the city of Roswell, Georgia, case number 2017CV294723. If I could get announcements for the parties, starting with counsel for the plaintiff.
Good morning.
Good afternoon. Good afternoon, Your Honor. My name is Darren Somerville. We do have a bigger team than was the last time. My office is staffed with Chris Alderman, and Jen Jordan was, there she is.
Yeah, she's just trying to sign there.
And then our predecessor counsel, Mike Fistel, Enoch Hicks, and Mary Ellen Connor are all here as well.
Okay, excellent. Well, I obviously know counsel previously who've been involved in the case, having seen them a number of times. And of course, I know you fine folks. I was enjoyed coming to your grand opening of your new office and your new firm very recently. And of course, Chris and I used to work together. So a long time ago. But anyway, and then now may I have announcements from counsel for the defendant, please?
Yes, Your Honor, Patrick Lale, and joining me is Tracy Glanton as well.
Okay. Hello, everybody. So let me start by congratulating you all on making a realistic announcement for how long it was going to take you to try this case. I recently had some lawyers look at me and tell me that it was going to take them 3 weeks to try a civil case. And I was like, I don't have 3 weeks to give you. And so when I saw that your announcement was 3 to 4 days, even if you are being optimistic, I was still pleased to see that you thought it was doable in some time frame that sounded more like a week instead of multiples of a week. So what I plan to do is just to quickly go through the pretrial order, make sure we all have our T's crossed and our I's dotted, then ask for any questions, insight, whatever, about questions you have about how the trial will be conducted, how we're going to do voir dire, those sorts of things. And then we will attack the motions in limine. And of course, I am aware that there has been an amended complaint, a second amended complaint that was filed that I assume we'll need to spend some time with. So let me start with the pretrial order. Do we believe, based on the number of documents and the number of witnesses, that 3 to 4 days is still a reasonable estimate? And does that include jury selection?
From our viewpoint, Your Honor, I know you asked some of the questions, and we'll try to, of course, ask as few as possible following on that. I think 4 days is probably, certainly a jury would get the case in 4 days. Deliberations, I'd always predict wrong. So something like that. But I think inside a week is certainly doable. But before we go forward, I do want to bring something to your attention that may not have crossed your radar quite yet. We did file a second amended complaint yesterday because the pretrial order had not been signed yet.
Right, I did see that.
And it does add some things to the case in the pretrial order as well. So before you red star and sign this, I would say we probably need to add a paragraph or two if we're going to try those issues as well. And obviously that's going to circle around to what I think you had targeted as last. But obviously, one of the big issues in this case is whether the summary judgment order on defined benefits was a bit of a hurdle for us. So we started putting our thinking caps on, and we found what I believe to be another theory that would allow for the trial of the case to include the defined benefits claims as well. And I know that this was last night, but we have all been working real hard and real well together, I might add as well, to get all this to the court in as consolidated a fashion as possible. But I did want to bring it to the court's attention because it might bear discussing that on the front end. If I don't know how my colleagues across the V feel or anything of that nature, or Your Honor, of course, but I did want to put that on your radar to begin with.
Okay, Mr. Leo? Or Ms. Clinton, whichever one's going to attack that particular issue.
I just want to unmute myself. I'll address that. We're happy to address it in whatever order the court deems appropriate. So if that's something that we need to address up front, that's fine. If you want to do it in your original order, that's fine with us as well.
I think what I think what I want to do is go through. I think I want to do the substance at the end in terms of what the claims look like, understanding to Mr. Somerville's point that may involve adding some language or paragraphs, issues, et cetera, to the actual pretrial order as it will ultimately be entered. But for now, I just want to go through the pretrial order in terms of, for example, Mr. Somerville had indicated, he thought 3 to 4 days for the case to get to the jury was acceptable. I think I understood him to say that included voir dire. Mr. Lael, do you agree with that estimate?
I do. Again, I think as we continue to work together and identify and narrow the exhibit lists, given the number of witnesses we have and the issues that are likely to come up with those witnesses, that's kind of my barometer. I think 3 to 4 days should suffice, including voir dire.
Okay, thank you. We typically, you get 36 jurors. Is there any reason that anybody thinks that y'all need more than 36 jurors to get a jury? Okay.
Not from our side.
No, that's true. I mean, you will obviously have to qualify folks that have a relationship with the city, but other than that, I don't see any particular unique case that would require more.
Okay. The motions in limine, obviously we're going to take up in a moment. The motion for reconsideration or in the alternative to certify the issue for immediate review. Obviously, I did not certify the issue for immediate review. My understanding of the law is that I'm not required to entertain nor rule upon a motion for reconsideration, but for record purposes, if the parties would like for me to be clear that by not ruling on it, I functionally denied it, I'm willing to entertain such an order. It looks as if there is an indication here that the parties have agreed to provide me with a proposed order, just so you'll have a clear record on that issue, that I was aware of the motion for reconsideration, that it was declined to be reconsidered. Okay. Anybody needs to add to the list of individuals or entities that everyone will be qualified as to?
I think certainly plaintiff's counsel should be on there. I mean, my understanding of this particular part of the pretrial order is these are individuals with financial interests
Yep.
in the case. So I think that all the members of my firm, I can't speak for Mike's firm as to how that's divvied up, but certainly his firm at least as well.
Who will a jury be introduced to at the beginning of voir dire? That's usually where I start from. Sometimes I can capture it with just the name of the firm if that's necessary. But generally speaking, it would be everybody that's listed on the pretrial. Mr. Fistel, Ms. Connor, Mr. Hicks, Mr. Somerville, Ms. Jordan, Mr. Alderman, and then the firms of Johnson, Fistel, and the Somerville firm, and then everybody that's listed on the pretrial for the defense and their firm. Is anybody going to take the position that that residents of Roswell should not be jurors in this case?
I just have a question with respect to that. Obviously, in terms of how any judgment would be paid, it's my understanding that it would come out of the coffers of the city. And of course, then the taxpayers of the city of Roswell would be hit with that. So the question is, how does that play in terms of qualification of jurors? And maybe I just haven't had such a direct link to that because normally there's insurance at play.
Mm-hmm.
But when you actually have a claim that impacts, dollar for dollar, what a taxpayer in the city of Roswell, has to pay, obviously that's more of a complication than we're used to.
Mr. Lael, Ms. Blanton, any response to that?
I haven't done a financial, I haven't sharpened my pencil and gotten out the calculator to determine the per citizen amount of the amounts that the plaintiffs here are seeking on behalf of the class and as fees, but I think it's pretty infinitesimal. So I don't think that this is something that should preclude members of or citizens of Roswell from being on the jury, but we'll take that under advisement to see if maybe there's some issue that would warrant that. And I think we have a later date for submitting voir dire proposed questions. So by that point, we'll, I guess, offer up any thoughts on that question.
Okay, thank you, Mr. Lael. And if my memory serves, some of that issue is touched on in one or more of the motions in limine that are pending. And I feel like if we have that conversation, figure out where we're going to go with that. My initial thought is that it might be an appropriate area of inquiry with jurors, but maybe not an automatic disqualification basis. But we'll see where we go with that. Okay. Everybody, discovery other than dealing with the class action, but the second amended complaint. But even with that, everybody's clear there aren't any outstanding discovery issues that we're dealing with. Everybody's got what they think they need or that they've asked for. Are we taking depositions at a time or in preparation for trial? What's going on there?
Yep.
Okay, excellent.
None of those issues, and we have Mr. Hicks asked us to take another look at our written discovery to see if any supplementation was appropriate, and we've done that and have no supplementation to make. Okay,
excellent. So I saw the exhibit lists that you both sent me, and I really appreciate, for purposes of printing them, that you put them in such tiny print. But for trial, if you could make it a little bigger, I would appreciate it, because I don't think my glasses are that strong to be able to see and make notes on the tiny thing. But for purposes of uploading it to the system and printing it, I do appreciate that. But I did get your exhibits. You guys have agreed on a later date to meet and confer and mark those exhibits where there will actually be an issue that you'll need the court to resolve. And so for now, mostly I will just make a note that both parties have submitted the exhibit lists in the form that I requested, as well as witness lists in terms of may call and will call. then the only other question that I really wanted to get into, and then I will open it to you guys in terms of process, is question number 10 regarding the contract. So it seems to me that there is some difference of opinion about what is the contract and whether it's all of the manual itself or relevant portions of the manual. And so I wanted to, the parties have attached, I guess technically all 200 pages of the whole thing. But I believe that the city's position is that there are only certain portions of it that are relevant. Is that correct, Mr. Lael?
No, Your Honor.
No, it's the whole thing.
The whole thing.
Okay.
The reason that there are two attached, of course, is that during the class period, I guess before the class period, there was a policy manual in effect that went through about the middle of the class period. And then the city adopted by resolution an updated policy manual, and that one took effect for the remainder of the class period.
And that was the 2014 one, correct?
That's correct.
Okay. Okay, and so all the parties are in agreement on those two policy manuals being the operative policy manuals, and the entirety of them are relevant to the case.
That's right. And with respect to the 2002 policy manual, obviously there are various amendments over the years, as noted in item 10 of the pretrial order. And we identified a couple of things that we thought were germane amendments to that version of the policy manual. And that's been included here on purpose because of the topic of those amendments. And so I think there's no question that those become part of the contract upon their adoption by the council.
Okay. And then I noted that the parties submitted two stipulations that are both related to the policy manual. And for purposes of later, making sure that I'm giving the right charge on the purpose or effect of a stipulation. You guys are stipulating to the admissibility of the exhibits, correct? Not the substance of those documents, or are you stipulating to the substance of the policy manual?
It's a little of both. It's that there, I mean, these will be authenticated. I mean that's not going to be an issue. And it's just that the stipulations basically cover the waterfront in terms of time. That was the purpose of the stipulation.
As in terms of when it was applicable?
Exactly.
Okay. Mr. Lael, agree?
That's right.
Okay. Okay. Those were the main issues that I wanted to go to. When was the most recent? Was it Tony Del Campo that y'all mediated with, or am I thinking of a different case?
Correct.
It was.
Oh, okay. Okay. And how recently was that?
May. I think it was early May.
Okay.
It was right before we came in board, so it would have been in the first 2 weeks of May.
Okay, so we gave it the old college try, unsuccessful. There are not any pending settlement proposals, but it says the parties are open to resolution. Is there? Are we going to call it fair, likely, moderate? How might we characterize that?
I'll go with fair minus. So.
Okay.
That's a reasonable assessment.
Okay. That seems reasonable. Okay. And, regarding the cost of takedown, it looks like the parties have agreed to share in the cost of takedown. I will tell you that as a function of the prioritization of criminal and the fact that there are criminal trials that still need to have transcripts generated for them that have already occurred so that they can have motions for new trial, you are going to need to arrange for your own court reporter, although I'm happy to accommodate her in any way that I can, but it will not be Ms. Taylor that will be taking it down for you. And I say her, could be him, didn't mean to sound presumptuous. In any event, other than the issue that Mr. Somerville had raised, which may result in, changes, it appears to me that the consolidated pretrial order is in good working shape. Did anybody have questions about the manner, the process procedure of how this will go before we move on to some of these more substantive issues specifically related to the motions in limine and the second amended complaint?
I would suspect in terms of voir dire, there's your standing order and then one that the parties sort of agreed to. And I just wanted to make sure I had it my head around it. So you're going to do generals. Is that
Yes.
just hardship and qualifications, or is that also more?
It is basically minimal qualifications. It will be everybody in the pretrial conference. It'll be qualifications as to everybody the jury has to be qualified as to. Whether they are minimally legally qualified to serve. And then the only difference that it may be from what different judges do it different ways. I do the general and then I let y'all do general. And I do that for sometimes what your experience might have been is after I ask the general questions, you get to ask questions. And if a juror raises their hand, you can say, oh, juror 27, why did you raise your hand to that question? What I prefer to do is for y'all, once you agree on what will be acceptable general voir dire, that you ask that voir dire in the same number card raising fashion. And then when we put the first panel of 12 in the box, and then you can ask all the individual follow-up questions that you want within the scope of both their their answers on general voir dire, as well as any individual voir dire that we've all agreed will be acceptable.
Judge,
Yes. Mhm.
in terms of we have to submit the voir dire questions. With respect to that, are those the general voir dire questions? You know, for example, does anybody here have an issue with respect to, class actions? That kind of
No,
stuff.
I leave that open to all of you. What I let y'all do that.
Okay, so we don't have to submit those questions to you.
The only reason that I ask you to submit your questions at all is so that I know that y'all have shared your questions with each other, so that if one side or the other says, that's not a fair question, don't let them ask that. There's an opportunity for that conversation. But other than that, you guys try your case. You ask the questions you think that are necessary to be asked, with the exception of don't take all day.
But to share, right? But to share
Yes.
that in general.
Yes.
All right.
And my only issue with letting you know that I do it that way is that there are questions that should be framed as a yes or no. Does this apply to you? Does it not? And that would be I'm going to raise my card because I think it applies to me. And then later you can say, you raised your card when I asked if you had strong feelings about class actions. What made you raise your card to that? That would be an individual voir dire when a panel of 12 is in the box. Okay. Anything else?
Normal trial day is
Usually 9 to 5:30. I try not to push it too far. The only caveat to that is that frequently in the middle of my civil trial week, I may have drug court on a Wednesday. I don't know if I do on this particular week, but if I do, it would just be that we would start at 1 o'clock in the afternoon that day, but I'll tell everybody in advance. Generally, my preference is we're going to take a break in the morning. We're going to take a break in the afternoon. We're going to take a lunch break. I try to keep it to as natural of breaks as I can. So if a witness is on the stand and it's only going to take another 10 minutes, typically let them keep going and push lunch a little bit or push a break. But other than that, the other thing I will say is I do prefer to have sidebars. So if you guys want a record, what my typical practice is if it's an issue that somebody just says, hey, objection, let's come up here. He's about to say this. I want, not to. I'll rule on it right then, and I will make a note. And as soon as the jury is naturally out of the room, we will make a record of that issue. If, however, you feel like the record needs to be made and there needs to be more fulsome argument that can be accomplished at sidebar before we move on from that point, you just need to tell me and I'll let the jury know, hey, listen, we need to ask you to step out of the room. I try to keep those to a minimum, but it's y'all's case and I'm going to do my very best to stay out of your way and let you try it the way you want to try it. So. Anything else?
Your Honor, I do have a couple of questions, just sort of procedurally. If a city witness is called as part of the plaintiff's case, do we need to go ahead and do all of our direct examination of that witness when that person is up, or do we call them back in our case? Just kind of different preferences sometimes on that.
I prefer that you be efficient, but if there is a strategy reason that you might choose to do one or the other, then I defer to you to do whatever strategy you think is best for your client in your case.
And I assume it'll be okay to take a witness here or there out of order if their current professional responsibilities kind of limit their schedule that week?
Absolutely. And I
And
do
then-
hate to have witnesses cooling their heels too much, but I also really hate it when lawyers are like, yeah, I've run out of witnesses today. So please over prepare. If you think you're going to get to 5, please have 7 available just in case.
Okay. And one other just sort of housekeeping thing. Part of our trial team list is Mr. Genilet and Mr. Devaney. Mr. Genilet, since we're on the record, I won't be in detail, but is experiencing some health issues, and that's why we added Mr. Devaney kind of at the last minute. So Mr. Genilet is not on now. I think Mr. Devaney is listening in, but I want to just confirm that it's okay that they can both take part in aspects of trial, given those circumstances.
And unless I'm hearing an objection from the plaintiff, I don't certainly have any concern about that.
Oh, of course not.
I think the next thing on our list is that in the plaintiff's witness list is mentioned a former mayor, Jerry Wood. And we discussed this with plaintiff's counsel the other day and asked, was he disclosed? And the answer was yes. And we've looked through our discovery. We don't see that he was. So we just want to register on the record that we have an issue with their calling former Mayor Wood as a witness in the case without having disclosed him. And I'm subject to being corrected if y'all can point to me where he was disclosed in the record.
Well, and I'm happy to respond to that in terms of former Mayor Wood. I'm not sure specifically in terms of discovery, but I mean, he was mayor of Roswell during the entire relevant time period and has made multiple public statements with respect to the particular scheme involving the firefighters and how it saved millions of dollars to the city of Roswell taxpayers. So I'm not sure how you wouldn't expect him to be called. So.
Well, I think a couple of things there.
And
There
we're
are
happy
articles.
to discovery deposition if you want. I mean, but
No,
he is an agent or was an agent of the city of Roswell. I mean, he isn't someone that we control or someone that we have power over. I mean, he's an actor. He's your actor. So I'm not quite sure exactly what the issue is.
Yeah, I think the complaint cites some articles attributing certain comments to him, but there's no, specific information that's been gathered for him or about him with respect to his involvement in any of these decisions. And furthermore, as a matter of just general public sector law, he is a single elected official. He doesn't speak for the body, the council, and it takes the council to make decisions on behalf of the city with respect to the benefits that we're talking about and the employment status of the part-time firefighters. So again, I'm not sure what he could really add. So, Your Honor, to the extent that they would intend to call him, we'd appreciate an offer of proof just to see that whatever they think testimony they could get from him would be actually meaningful for the trial.
Okay. So I've made a note that you guys have raised that issue. I think what I'm hearing fairly characterized from both sides is that given that he was the mayor during the relevant time period, and allegedly has made statements publicly about this issue, that it would have been, there wasn't a notice issue in terms of that he might have relevant knowledge, but to the defendant's position, he's never been identified by the plaintiff or another, in discovery as a person with relevant knowledge or a fact witness, at least based on this juncture. Mr. Lael believes that's the case with discovery. So I think that fairly characterizes both the substance and procedure of where we are on that witness. And I think that we will deal with it as the parties come together on their meet and confer and on what exhibits are going to come in relative to perhaps media statements that were characterized, et cetera. But it has been noted, Mr. Lael.
Okay, thank you, Your Honor.
Okay, anything else?
You know, I think for us, maybe the last thing is, and this is in the pretrial order topic 8, the last bullet point. We raised the issue of the arguments we made on summary judgment that the court determined were not sufficient to grant a summary judgment. But I want to do that for 2 reasons. One is one of our colleagues is kind of helping behind the scenes with the case suggested that we needed to raise it for appeal, but I don't know that we do. But second, that the contract disclaimer language is part of the policy manual and therefore part of the contract for purposes of this case. And so ordinarily, in considering the contract as a whole, that would be something that would be part of the equation. But in its summary judgment order, this court determined that the disclaimer was not effective to take this out of the realm of being a contract. And so I just wanted to make sure that we understood and had clarity from the court whether we can present disclaimer information, evidence about it, argument about it to the jury in the trial, or whether that is something that the court deems to have been judicially determined and is not up for debate or for decision by the jury.
What my ruling was that as a matter of law, the court was not going to determine that there was not a contract. And the court was not going to determine as a matter of law that the disclaimer had the effect of defeating the existence of a contract. That doesn't mean that if the whole contract is coming in, the fact that there is a disclaimer, I suspect, is going to be argued by both sides for very different purposes, and fully expected that it would be.
Thank you for that clarification.
Anything else?
On the pretrial order, I don't think so.
Okay. So I'm gonna put a pin in this for now, to the extent that we may need to add to it before I make it final. After we deal with the second amended class action complaint. And I think that we should take that up before we get to the motions in limine, because it may affect the admissibility or framing of other issues in the case. So here's what I think I understand, Mr. Somerville, to your point, having reviewed the second amended complaint, having gone back and reviewed my ruling on summary judgment. My understanding is that in early 2011, the city of, and of course, I'm telling you all this so that you can make sure to correct me if any of what I'm saying is factually incorrect. My understanding is that in 2011, early 2011, the city of Roswell converted from a defined benefit plan to a defined contribution plan. And when this lawsuit was filed in 2017, more than 6 years had elapsed from the time that change had been made. And so as part of my ruling on summary judgment, I determined that the traditional 6-year contract statute of limitations applied, and that the defined benefit plan was not an issue in this case because more than 6 years had lapsed since the defined benefit plan had been done away with, and this lawsuit had been filed in 2017. Now, also taking into account was an argument that the plaintiffs had made on summary judgment that this was that the defined benefit plan, each time it failed to be paid, that it accrued each time. And my decision was that that might be relevant if each time was an issue of whether or not or how much it was to be paid, which seemed to be what the case law indicated to my way of reading. But that because the issue remained the same every time, which was, are they or are they not entitled, that there was no ongoing accrual each time a payment would have been made. And so for those reasons, I ended up granting functionally a partial summary judgment to the city regarding the defined benefit plan based on the statute of limitations. As I understand the second amended complaint to the class action, it seeks to revisit that issue on the basis that there is an applicable 20-year statute of limitations that would apply to a retirement plan of this type under Georgia law that would take it outside of the 6-year contract statute of limitations. So that's what I think I understand to be the issue. Anything that I've said that's incorrect, or if it's not the issue, please share with me, Mr. Somerville, and then I will hear a response from Mr. Lael.
It sounded better than I'm probably going to put it. I think that was exactly right. I mean, if we're traveling under a 6-year umbrella, and we set aside the Plymel or Plemmel case, the one about successive payments, then after your honor's ruling, I think it was back in April when the summary judgment order hit, we sort of started looking around and opened up our old textbooks from law school and found contracts under seal. In Georgia, there's a 20-year statute. If that's correct, then obviously the defined benefit plan is on an altogether different footing. We explain it and we put in some, I'm sorry about the amount of paper, but it is what it is when you deal with these sorts of contracts. They're really both a statutory argument and a contract argument, all of which are under seal. Literally, there are seals on them, that you can see the old gold leaf on. But that's our argument, is that under the municipal employee benefit system, for one, obviously the board of trustees of that particular entity signs contracts with municipalities all around the state, including Roswell in this case, that extends the statute back a good bit before 2011. And there is a precise third-party beneficiary language in that contract. I mean, it could not be clearer. We all know the rule about third-party beneficiaries. You have to specifically spell it out in the contract. You shouldn't imply it. No implication necessary here. It just says it. This contract is for the benefit of the employees of the city of Roswell. Period. End of story. In addition to that, of course, there is a statutory concept, much like there's a 6-year statute for written contracts. Generally, there's also 2 statutes that you do have to specifically plead, and that's the reason we put them in the second amended complaint that says if you want to plead there's a case that says this. I don't know if it's really accurate, but why not? That says if you want to travel under a 20-year statute, obviously that strikes some people as like 20 years, holy cow. But the statutes say exactly what they say. Contracts under seal are governed by a 20-year statute of limitations, and thus the defined benefit plan would be proper. So, and that's the sort of, in a nutshell, what we're arguing here. And we would add that to the pretrial order, or ask that we be allowed to do that.
Okay, Mr. Lael.
Your Honor, I'm going to start with 91115, which is the rule about amendments. And because this amendment comes before the entry of the pretrial order, Georgia law gives pretty wide latitude for the plaintiffs to do exactly what they just did, that notwithstanding that we're 6 years into this litigation, they're adding a new theory and a new basis for their claim at this 11th and a half or 3/4 hour, wherever we are. And by operation of the statute, a defendant may respond and may move in response to an amended pleading, and that is our right, and we intend to do that. With respect to what Mr. Somerville just summarized, they have alleged a 20-year statute of limitations, which the Court of Appeals has held does not apply to public pension plans. So we intend to move to dismiss on that basis, and on the basis that having granted summary judgment, this matter's been adjudicated. And the plaintiffs are seeking to kind of reopen the book there on summary judgment. And there's another ground that we're looking at. I mean, we only got this yesterday, so we're just sort of getting our initial impressions here, but I think there may be one other significant basis on which to move to dismiss. And so I guess what I'm communicating is we intend to do that, and we believe that this is a substantive motion, not just okay, well, we don't know what to do, so we'll file a motion to dismiss. We think there are good grounds here to dismiss this claim as articulated.
Well, to your point, so my concern is primarily, I assumed that you would have a response of some sort substantively. Particularly, I'm not familiar with the law in this area. I also just got it yesterday. I haven't spent time with it. But I did expect that I would hear something along the lines of, you've already ruled on this at summary judgment, and the only statute of limitations that was discussed at that time was the 6-year contractual statute. So I expected that. My main concern, though, is as we sit here now, let me look at a calendar. This matter is supposed to select a jury on June the 27th, which is 20 days from now. I'm certainly able to rule on it, on any motion that is presented to dismiss or to deal with it substantively, prior to trial. But it would necessarily be immediately prior to trial, depending on how much time the defendant believes is necessary to properly respond.
And I appreciate that, Your Honor. Again, just having gotten this yesterday, I think it's going to take us some business days to put together the motion and fully flesh out what our position is on this issue. And then, of course, the plaintiffs will need some time to respond to it, and then the court will need some time to consider it. In as much as this would substantially change the landscape of trial, I guess if what I'm hearing the judge suggest is, can we squeeze this in before the current trial date? My only request is if this gets continued, that the judge enter the pretrial order so that we don't have any other amendments.
To be clear, no, I would go ahead and enter a pretrial order. It would just include that there is a second amended complaint and potentially a pending motion to dismiss or some response the court's not yet adjudicated. I agree with you there. But to your other point a moment ago, one of the things that I was struggling with when I was looking at this is, of course, it's not like, Sandy Springs. Roswell's been a city forever. So I don't know how far back it goes. I think it starts with an 18. Like the city of Roswell's been a city since like the 1800s, I think. Going back 20 years, from a practical perspective, I had two concerns when you say, Mr. Lale, about expanding the scope or the nature of the issues to be tried. Two things. One is there is a motion in limine from the plaintiff's perspective seeking to limit the ability of the defendants to re-argue the nature of the class. And so one concern I had is, does this expansion back 20 years of the defined benefit plan have the effect of attempting to or potentially functionally changing the class? Which, as the plaintiff has pointed out multiple times in their motion in limine, and the Court of Appeals has told us multiple times, has been litigated extensively. So I do have one concern there. And two, from a practical perspective, if we go back 20 years, who and how does it really affect, right? Because the class that we have in practical terms is not a particularly large class, right? We're not talking about thousands of people. And so my question is, how much does it really expand the nature and scope of the evidence if the amendment were to be allowed? Because as a side note, Mr. Lale, I will tell you that having practiced fairly extensively in federal court, I was always a big fan of the rule that you can't amend after a certain time. But when I became a judge, I was like, the statute's pretty clear. And although I know I'm allowed to have an order that says you can't amend after a certain date without leave of court, that seems to me to go against what the statute was intended to accomplish. And so that's why I don't have such a limitation. But it does often create issues like the one we have here, where we're ready to go to trial in a case that's been extensively litigated, and now we're sort of introducing a new issue. But with that in context, from your perspective, and I understand this is sort of extemporaneous, right? What is the practical effect if the amendment is allowed? Are we talking about a number of people? Are we talking about an exponential factor of damages? What is the practical effect?
Well, I think one practical effect is, the class certification, as you say, has been extensively litigated. and a damages computation has been prepared by the plaintiff's expert. We've got an expert who's done the same thing. So if the court were to allow the amendment, allow this area of relief sought, and we go back 20 years instead of just keeping the current 6 that we have, number one, that's going to involve giving notice to additional people that might not have been included in the 6-year period. It's going to involve having the plaintiff's expert and the defendant's expert crunch the numbers again, because then maybe you have a handful of people. I would surmise that the people that were deemed eligible under the defined benefit plan by plaintiff's expert for the 6-year period probably had some eligibility years before that as well. But whether there's some more people that maybe dropped off the rolls before 2011, I don't know. So there are a lot of ramifications that may come into play if this amendment is allowed and this kind of additional new theory is pursued. So I think all of that kind of opens up some territory that, as much as I hate to say it, and I would rather get this case resolved for the city, and I think also the plaintiffs would prefer to do that as well. This late hour amendment may require that we first brief the issues and see if this is even subject to being actionable, and then after the court reaches that determination, figure out where we go from there.
Okay. Mr. Somerville, from your perspective, what
Sure.
Same question.
Well, keep in mind that for the vast majority of the lifespan of this case, the defined benefits plan was part of it. And so it's only past April that, we've been in this sort of ambiguity. And if under our interpretation, what we're looking at, and we did have pre-2011 data to some extent, because to determine, for example, service time benefits that are based on service time, we needed to know before 2011 how some of our class members were employed, how long they were employed, what they were paid, and so on. So we do have a good bit of that historical data. I am not a master of that data. Those are my colleagues who are on the other sides of the screen. But so I think that information, the raw data, is something that is known to us. And in our mind, what we were searching for, frankly and candidly, was just a way to get the defined benefits plan back into the fold. And if the statute is what it is, then we already know what our experts have estimated the value to be. Those numbers are, disputed, of course, because we have dueling experts, but that doesn't mean they're a complete mystery.
Okay. I think I understand the issue. I will say that from my perspective, I think the real issue is going to be, how do we reconcile the 20-year issue, statute of limitations, potentially assuming that that's the correct law that is applicable, with what has been essentially for 6 years the law of the case, right? Well, maybe not for 6 whole years, but that in part the class was defined by the contract statute of limitations period. And so that's the real concern that I have. But what I'd like to do is, I feel like it's taken a real team effort to get us this close to the goal line, and we're so close. Candidly, I have literally 100 criminal cases I could try during the time that you guys are going to take to have this case tried if we end up needing more time, but that is not my preference. My preference is, we had targeted this case to be tried June the 27th. I want us to go forward with this case if it can reasonably be accomplished. The reason I asked about the fact that we are 20 days away is that if the city intends to move to dismiss or in some manner respond to the amended complaint, which is its right, if it chooses, then realistically, we need to have an idea of how soon reasonably the city feels that it would be able to do so intelligently, in a way that preserves its rights in writing, but also in a way that gives at least a few days or a week-ish for the plaintiffs to respond so that we would be prepared to deal with this issue without moving the trial date that is currently set for the 27th of June to select a jury. And that's my primary concern is if I tell y'all that that's what we're going to have to do, understanding that once we get that substantive briefing and the parties' positions on it, that depending on what that shows and how I rule, that ruling may delay the trial, but that we would have to get to that point still with an eye towards going to trial on June the 27th. What are your thoughts, Mr. Somerville?
Yeah, I mean, we knew that, you know, we're going to put this before the court. I was elected to catch the spear. So we understood the possibility that, you know, these arguments are all, you know, still in the air at this point. If you tell us that we have 3 days to respond to whatever motion that my colleague wants to file, be it dismissal or summary judgment, we'll do it. And if you tell us to show up on the 27th, we'll be there.
Okay.
So,
Mr. Lael, realistically, understanding what you're trying to accomplish, when do you think you could realistically submit whatever response or planned motion, et cetera, that the city intends to present?
Yeah, I just muted myself and we kind of discussed. I think next Wednesday is probably realistic. We might be able to do it sooner, but I think next Wednesday is probably a reasonable point to aim for. That's a week from today.
Okay. I applaud you for giving me as much wiggle room as we could possibly have. Because if you were to file whatever you're intending to file by next Wednesday, then by June the 20th, because June the 19th is a holiday, June the 20th, if you guys file whatever you're going to refile by way of response, assuming that it is a motion to which the plaintiffs will need to respond or want to respond, what I would do is have the city file whatever it's going to file by the 14th, and plaintiffs file whatever response they wish to file by the 20th.
sounds good.
And that way we'll have a little bit of wiggle room at the end of that week if we need to have an impromptu hearing by Zoom, or, you know, whatever, to revisit these issues and figure out what the ruling is going to be and how it affects our ability to go to trial, or how the issues will be presented and characterized at trial. Does that work for everybody?
Yes, Your Honor.
Okay.
I believe so. And again, I think if what Mr. Somerville is proposing is that the experts work with the data they have, I suppose that is okay with us. If you can give me just a second for a short conference here.
Sure.
Thank you, Your Honor, for that time for us to just confer about things. Inasmuch as this is a new theory of recovery, it occurs to us that the 20-year period, were it to apply, would only begin at the filing of the second amended complaint and not relate back to the original complaint. So I think that would only take the parties back to 2003 and not the very beginning of the data that the experts had. And also, again, not knowing exactly how this 20-year issue would play out, I think it's an issue more for the plaintiff's counsel than for us as to whether any additional notice might need to be given to other people. Again, that's really more of a plaintiff side issue. Are we going to go with the class that we know about from the 6-year period that we've been working with all along? Or are they going to seek to expand the class to people earlier than that? I think I'd be happy to stay with the 6-year crowd if this is even actionable, but that's probably more of a question for them.
Well, and I think that the nature of this conversation and the fact that we are going to give you some time to brief and give the plaintiffs some time to respond, I think also affords both the attorneys some opportunity for some strategy discussions about what is the practical effect on the case, what is the intended effect on the case. Because certainly I understand Mr. Somerville looking at the case and thinking legally, is there a way that we can get this issue back? But because having to do it on a short time window, having not really maybe had an opportunity for everybody to figure out what is the practical effect of this. And to Mr. Lale's point, whether it requires additional notice or other issues, or as I said, because when I saw it, I don't know anything about the law of contracts under seal and 20-year statutes of limitations in full disclosure. But immediately upon seeing it, the main concern I had is, does it change the nature of the class? Because the class was itself defined, and that definition endorsed, I think, by the Court of Appeals as that 6-year period. And so those are issues that I trust you, counsel, to work through over the next couple of weeks, and then we can revisit it once I am better up to speed on the law and the parties have had a chance to look at the law, present the law to me, and then also figure out what practical effect it has on their case. Excuse me. So for now, I'm going to put the second amended complaint off to the side. What I am going to ask the parties to do is to submit to me before the end of the day a new consolidated pretrial order that includes reference to the second amended complaint and the fact that the defendant reserves the right to respond and or move against that amendment, and that the court will resolve that issue at a later date on the schedule that we've discussed, so that I can go ahead and get the PTO on file so that all the parties are clear that the case is what the case is at that point, subject to ruling on that second amended complaint.
And we'll also add in the names of counsel in the qualification section, just
Yes,
to make sure it's comprehensive.
that will be helpful. That way it's just one list I have to look for instead of referring back to an earlier page when I'm calling that list. Okay, I think that takes care of that issue for now, and that we're ready to move on to the motions in limine. Everybody in agreement on that?
Right. Does the revised PTO we submit today contemplate that the trial date stays, July 27th stays?
Yes, sir, it does.
Okay.
Okay, so moving on to the motions in limine, let me first thank you for the most part, y'all did not give me please enforce the law motions in limine. I really hate those. And I thank you very much for not giving me 70 pages of please don't let them do this thing that the law says they can't do. So for the most part,
Hearsay's bad. Unauthenticated documents are bad. Yeah,
that's right. That's right. All bad. And you're right. They are all bad, but we all know that. So for the most part, my read of the motions in limine are that they were tailored to specific issues and concerns that the parties had in the case. I'm going to start with the plaintiff's motions in limine. You will note that I asked you guys for you to submit them to me in Word format. And the reason that I do that is after I rule on them, I will enter an order on motions in limine. Because that is the expressed preference of the Court of Appeals. And I also think that it provides greater guidance to the lawyers when they're in the trenches trying the case, to have something in front of them reminding them of what the rulings were so they can figure out how they want to navigate them, as opposed to having to retain all that in their head. That's number one. Number two, I will tell you that generally speaking, not always, but generally speaking, all of my orders will say two things that are probably important to you. Number one is whatever I say, if you can't make this argument, if the plaintiff says, don't let the defendant argue X, My ruling will say no one may argue X. So my rule generally, unless there's a specific reason to handle it otherwise, is what sauce for the goose is sauce for the gander. And if it's not relevant and the plaintiff shouldn't bring it up or the defendant shouldn't bring it up, then really nobody should bring it up. The second thing that all of my rulings on limine motions will say is absent a demonstration of specific necessity and an offer of proof, right? So once I rule on a motion in limine, if you believe that the door has been opened or that circumstances have changed, you are free to raise that to me and say, here's the specific reason why I think you need to revisit that ruling. And here's the proof that I intend to offer on that issue. Those are all fair game, but those I tend to frame my rulings on in limine the same way every time for that reason, for consistency's sake. And also so that everybody's clear that just because you decide that maybe the door has been opened, you don't get to just plow through it until you say, hey, judge, I think the door got opened and here's the stuff I want to push through the door. So with that proviso, we'll go ahead and get started with the plaintiff's motions in limine. Also, I do want to say this, that just for efficiency's sake, even though you have mostly tried to limit it, I do like to start often with the opposite side, because there's no point in Mr. Somerville arguing every motion if the defense's position is, yeah, we don't object to that, it's fine. So starting with number one, settlement communications. That would seem to be fairly obvious, but sometimes in cases like this, where classes have moved around and who's in and who's out, might be an issue, but perhaps it's not. Mr. Lael or Ms. Blanton, who am I going to hear from on the motions in limine?
I'm afraid it's me again. Your Honor, we submitted a Word version of a proposed order on the party's motion in limine.
I did not see that. I'm sorry.
Okay, so in that, on the areas where we reached agreement, that document shows the parties agreed, blah, blah, blah. And we had emailed back and forth about the language of those agreements. So I think we're good to go on several of those. And I can give you the numbers if you'd like to know what you can.
The easiest thing to do is if somebody has it readily available, if you can email it to me, because I received the Word versions of your motions in limine. I don't believe, and if I have, I've lost it in my email, a Word version of a proposed order on those motions.
Yeah, I'll find what I sent earlier, and then
okay, and then so
yeah,
so if you want to just run through the numbers, and then perhaps somebody on your team can also email it to me real quickly, that would be great. But go ahead, Mr. Lael.
I'll just say that the ones we had agreement on are plaintiff's topic 1, plaintiff's topic 3, plaintiff's topic 4, plaintiff's topic 6, topic 7, topic 8, topic 11, plaintiff's topic 11, and plaintiff's topic 15.
Okay, and what about let's stick with plaintiffs for right now. We'll go ahead and argue through those, the ones that are remaining where there was not agreement. So starting with the city's decision to terminate one of the named plaintiffs, Brian Rogers. Mr. Somerville?
I'm going to hand these off to my partner, Chris, Mr. Alderman.
Okay, Mr. Alderman.
I from time to time, I'm told that I talk too much. So
I think every lawyer I know suffers from that disease. Every single one.
Oh, I was talking about my wife, but okay.
Go ahead, Mr. Alderman.
Thank you, Your Honor. Our second motion in limine, it pertains to the termination of class representative Brian Rogers. This termination occurred after the class period. Candidly, we had some debate about whether we wanted to exclude this because it does seem to us to be a retaliatory termination. But
I'm glad you said that, because that was my first thought as well, that you would be perfectly happy to argue that the city retaliated against him. But anyway, go ahead.
we thought on balance, we didn't need to have a mini trial over whether he was properly terminated or not. And so the best path forward would be to simply exclude any evidence of his termination, which has absolutely no bearing on whether the firefighters in the class are entitled to these benefits. So rather than make that an issue in this case, we thought it'd be better not to raise that and not to create a sideshow. When we met and conferred, what we heard is that this termination potentially is relevant to Mr. Rogers' character for truthfulness, and I won't speak for them, but I think that's the argument that they'll make. This is I guess we do have to get into a little bit of a sideshow to explain this motion.
So what was the basis for the termination? I think I need to know that information before I can decide how far we're going to go into it.
Absolutely. Our understanding is that he was terminated because his group of firefighters went to another fire station within the city of Roswell and saw an open or a new shop vac. And they took that shop vac and brought it to their station because they had asked for a shop vac. And that is what we understand is the basis for the termination.
Okay.
We don't think that has anything to do with the issues. If they think that bears on his character for truthfulness, we're actually comfortable letting them argue that, because I think he'll come across as very truthful with the jury. But our intention with this motion was just not to distract from the real issues.
Okay. Mr. Lael?
Your Honor, Mr. Rogers was terminated as part of an investigation into his crews taking a boxed shop vac from another station. In that investigation, the other people on his 3 firefighter crew acknowledged that, yes, there was a box in the back when we came back from that other station. Yep, I didn't put it there, but it was certainly there right next to Captain Rogers. And the other one said something similar, but Mr. Rogers said, I don't remember. I don't know what happened about that. And ultimately, the fire department did an extensive investigation thinking, had there been a robbery, a theft from that fire station? They went to all these efforts, and Mr. Rogers repeatedly, or Captain Rogers at the time, repeatedly said that he didn't know anything about it. And finally, when he was confronted about it by the chief, he acknowledged that he had not been forthcoming. He was terminated, not for the removing of the shop vac from one station to the other, but for not being forthcoming as part of the investigation. And so he was let go. And significantly in his deposition, I pointed out that even part-time employees at that time had the right to appeal a decision like a termination. And he acknowledged he didn't appeal it because he agreed with the basis for the termination. So he is a class representative. So I think his credibility is an issue in the case always, because class certification is always sort of a little bit in limbo. So I think it's relevant for him. Now, you'll see in our response to the motion in limine, we offered a proposal that they have a motion in limine, or we have a motion in limine that the plaintiff—
I was going to ask about one of your witnesses, right, who had some issue with their GED way back in the day.
That's right.
Okay.
And that one is, to my mind, not to skip around between the different motions in limine, but since we offered that as kind of a trade-off, Chief Burnett, when he was in his 20s, I guess, made apparently some sort of representation that he had a high school diploma that at that point he hadn't completed. And based on that, there was an issue, I think, from an ex-wife raising something. There was an inquiry into whether he had that degree. And ultimately, it was shown that he did not, but he rectified that in 2005 by completing the GED. And so from that point on, he was good to go. It seems to me that that's pretty old news at this point, whereas the Brian Rogers termination was not within the class period itself, but certainly within the litigation period, and is much more recent, and as a class representative, certainly more probative of his and related to his role in the case, whereas Chief Burnett is someone who doesn't have any specific authority as to the interpretation of the policy manual. That's left to the city administrator, and then of course ultimately to the elected body, the council, in approving or changing various elements of the policy manual. So we don't think that Chief Burnett's credibility per se is at issue nearly as much as Mr. Rogers, but we're willing to say we won't ask about Rogers' termination if you don't ask about Burnett's educational credential and earlier representation issue from, again, like 40 years ago.
Mr. Alderman, what are your thoughts about that?
Thanks, Your Honor. The only way that the information about Mr. Rogers' episode with the shop vac is the only way that comes in is under Rule 608B, which means they could cross-examine him about it and take his answers. They can't offer extrinsic evidence because clearly that episode has absolutely nothing to do with the issues in the case. There's no way to get them in under the 401, 402, 403 analysis. But under 608B, if they want to cross-examine him about this episode with the shop vac and what he may have said, okay, but they don't have to talk about his termination to do that. And what I think is, if we skip ahead to their to Mr. Burnett, I think the remedy here is not none of this comes in. It's that that both sides are able to question the character for truthfulness of a witness, because anyone who testifies at trial can be impeached on their credibility for truthfulness or untruthfulness. So I think I think the remedy is not, you can't talk about either person's character for truthfulness. It's that you can talk about both. But even if you can talk about this episode of the shop vac, the termination still doesn't come in because that doesn't matter to his credibility.
Well, I think one thing that I wonder about, I don't disagree with either of your assessments. One thing I do wonder about, though, is practically speaking, I assume that somebody's going to concede or acknowledge to the jury that Mr. Rogers no longer works for the city. It seems to me that you're going to leave a hole open if you are not explaining to the jury how or why it is that Mr. Rogers either abandoned his role as a class representative by leaving the city in some way, right? There might be an argument that he's weakened his position or that he was retaliated against. And I'm overthinking it, I'm sure, but it feels to me like, how are you gonna avoid that issue with the jury?
Mr. Rogers is currently a class representative, so his termination has no effect on his ability to serve.
And I meant that colloquially because
Okay.
he no longer actually works as a firefighter for the city.
Okay, I'm sorry. I wanted to bring that up because there are two class representatives, and we'll talk about this later.
Who left, right, who are no longer class representatives.
Right.
Okay.
And Your Honor, I would just say that if the court were to disallow inquiry as to either Burnett or Rogers, I think all we would elicit from him testimony-wise is that his employment with the city ended on whatever date in 2018, and not get into the characterization, was it termination, resignation, the reasons why, and just sort of establish that he doesn't work there anymore, but not get into any other detail.
Okay.
That sounds like this is an agreed motion then.
It sounds a lot like y'all are a lot closer to agreement than otherwise. And I feel like if y'all can agree on how to characterize Mr. Rogers' separation from the city, that it would be the safer course of action to avoid getting into either of the topics, except to the extent that perhaps one of the witnesses, which I'm sure they won't because y'all will prepare your witness as well, takes the stand and says something crazy that just invites us to get into all of this mess. But if the parties can do that, I think that would be my preference, that we stay away from the specific circumstances of Mr. Rogers' termination, other than the fact that he is no longer employed with the city. And that for the same general reasons, we would stay away from any historical issue associated with Chief Burnett and his not disclosing his lack of a GED or maybe improperly claiming credit for one that he didn't have at the time. Okay, so 2 is going to be granted in terms of the circumstances of the termination, but the fact of termination is coming in. And then I think we'll move on to number 5. I will start by saying that I thought that it was particularly an effective technique to characterize this as a collateral source. I don't think it actually is, but I think it was particularly effective from an argumentative perspective to try and characterize it as such. But with that caveat, go ahead, Mr. Alderman.
Yeah, so I hope we acknowledged as much as what you just said in our argument. We certainly intended to. It's not the classic collateral source, but what we're concerned about is the same issue that the traditional or classic collateral source rule is concerned about, which is that if the city is able to put on evidence that these firefighters had benefits elsewhere, we're afraid that that improperly tells the jury that the city doesn't owe these benefits because these firefighters are getting them somewhere else. And that's the question of whether those benefits are owed is decided by the contracts, not by whether or not there are benefits available elsewhere.
Well, so Mr. Alderman, in looking at it here, and it may be that there's a distinction, there's a line that we can draw here, but in looking at your motion, what I agree with the general assessment that probably the fact that, say, Mr. Bible has $500,000 sitting in a 401k from, the Sandy Springs or City of Atlanta or something like that, probably not relevant. But I do know that part of Roswell's argument all along has been that these individuals treated the Roswell job as a part-time job because their perception was they were full-time employees with full-time benefits with other cities and other jurisdictions. And if I'm correct that that's been the city's argument and probably why they didn't agree with you on this, is there some line that we could draw that says we're not going to get into the dollar amounts, but the fact that they did have benefits and were and understood themselves to be full-time and in the way that they understand benefits flow from that, is that a line that the plaintiffs would be willing to agree to, or no, stand by the position that none of it should come in?
But the problem with that is that these firefighters, we haven't agreed on the exact number, but there's somewhere around 140 to 110 or so of them, and they have all different circumstances in terms of other jobs or not. And some of they do different things. Like you mentioned, Mr. Bible, he worked at Dobbins Air Force, so he got some benefits, federal benefits from that. But there are other firefighters who maybe they have a pressure washing company that they're not getting benefits from. So it's all across the board. And so it wouldn't, and that evidence isn't even, we don't have record evidence of every single class member's other jobs, if they have them, or other benefits. So what we're concerned about is if any of this gets discussed in front of the jury is going to subtract from whatever award they would otherwise make based on what the contract said.
Right. Okay. Fair enough, Mr. Alderman. Mr. Lael?
Your Honor, we actually didn't gather information about the value of these different benefits. What we did in discovery is discover that as part of Mr. Bible's employment at Dobbins, Mr. Rogers' employment with, I think he was Gwinnett Fire Department, that they had availability or access to various benefits. We didn't try to draw out the dollars because it's not our goal to say, well, you should reduce Mr. Bible's benefit by this much because this is how much he's getting in LTD coverage or retirement benefits or whatever. That's not the purpose of our articulating that they have other employment and they get benefits from that other full-time employment. The purpose is to explain how the part-time staffing model at Roswell could work. And part of that is that they had full-time jobs and they had benefits from those full-time jobs. And that in part is why they weren't beating the door down in Roswell saying, hey, how come we don't get benefits? It's also part of how the witnesses who will describe the scheduling process, for example, will describe how you work around the firefighter's full-time job in scheduling how they can work part-time for the city of Roswell, their own giving of availability each 28-day cycle was done based on when they were working their full-time job. So the fact of these full-time jobs is inevitable to come out. And I think while a juror may assume that anybody with a full-time job is getting full-time benefits, I think we just want to bring out the fact that for these two class representatives, they certainly had the availability of a number of types of benefits, including retirement benefits, health care, paid vacation, paid sick leave, that kind of stuff, and that was available to them. Again, we're not quantifying that and suggesting that the damages calculation should be reduced because of what they had available to them. So again, it's really just trying to set the landscape so the jury can understand how a part-time fire department would work. I think we're going to have to educate them a little bit on just how fire departments work, but especially with respect to giving them a clear picture of how a part-time department could work. And I think if, as we put, I think in our response, it would actually be prejudicial to us if the information that they had full-time employment and benefits from full-time employment would be prejudicial, because otherwise the jury would be sitting there thinking, gosh, these guys worked a good number of hours. Why didn't they get benefits? So I think it would work to our disadvantage if this information were omitted or excluded from trial.
The fact that there are other jobs is not what we're trying to keep out. It's just the benefits. And the last comment about being prejudicial, that's exactly the point of this case. They worked a lot of hours. In fact, they worked enough hours, in our view, to get benefits. That's not prejudicial. That may be detrimental to their case, but not prejudicial, and certainly not unduly prejudicial.
Okay. Well, I think that I've probably already given away the ghost in terms of what my assessment is of this issue, which is I agree with the plaintiff that any evidence about specific dollar amounts, specific, this many anything to do with specific dollar amounts in terms of other benefits that the parties may have received from other employment is going to be prohibited. However, I agree with the defendant that the fact of other employment that looked like, since what we're going to spend our time in this trial talking about is what is full-time employment under the terms of this contract. I think it's absolutely fair argument for, the plaintiffs to argue that it doesn't matter what else they had and what their understanding was. It matters what the contract says. And I'm sure that that's the argument that I will hear. But I do think that the class members' understanding that of what full-time employment looked like, because they had other full-time employment and received those benefits flowing from it as a general proposition, is fair game. And so the fact that they were treated as full-time employees by other employers and received benefits that flowed to them in some form is going to be an admissible set of facts, but not anything to do with dollar amounts.
Thank you, Art.
Okay, number 9. I'm gonna hijack number 9 and tell you that, generally speaking, I am inclined to agree with the plaintiff that we are not going to relitigate who's in the class, who's not in the class. But this new issue of the amended complaint, the second amended complaint, I think injects that issue from the other side. And so I'll hear argument on it if you want me to. But I think in discussing that second amended complaint, one of the things that I have indicated already is sort of my predisposition that the class is what the class is, and that the city should not be arguing that people who are firefighters within this 6-year period somehow are not entitled to be considered class members potentially, unless unless there's some specific reason. But I may have to revisit that issue if we go down the road with the plaintiff of this 20-year class, or 20-year statute of limitations that may affect the class definition. So all of that is a long way of saying I would be inclined to grant the plaintiff's motion in limine number 9. But I feel like we have to put a pin in it until we resolve the issue of the second amended complaint. Is everybody good with that issue for now?
Yes, Your Honor.
Well, Your Honor, I'll just chime in with perspective from the city. The class certification is firefighters who worked in specific years, no question about that, who worked 40 hours or more per standard work week. But the calculation of damages by the plaintiff's expert uses annual figures to average out who averaged at what he would contend is a 40-hour work week. And our position is that doesn't meet the standard that the plaintiffs got certified of 40 hours or more per standard work week. We also reserve the right to present the policy manual language that says a standard work week for employees is 40 hours in a kind of Sunday to Sunday time period, and public safety doesn't have a standard work week. Public safety operates on a 28-day pay cycle. And so we reserve the right to point out those aspects of the policy manual in conjunction with how the firefighters were actually scheduled and how their pay was allocated and tracked on a 28-day cycle. So again, we're not trying to tinker with the class definition, but whether the plaintiffs have introduced evidence to establish that their supposed class members actually meet that definition, I think is fair game.
And I don't disagree with you, but that's fair game based on the evidence that the parties are going to offer in terms of what does the contract language say? What do the experts characterize and how did they do their evaluations? What factors and evidence did they use to form those opinions? I mean, that's all what I expect I'm going to, hear at the trial. But I've already said that the language of the contract was required resolution by a finder of fact. And so those phrases about what a regular full-time employee is and what a standard work week is, I think those are issues for resolution by the jury. And so I don't think that's requesting that we revisit the class definition. But I still am going to say that we're going to put a pin in number 9 and get a clarified ruling on that once we figure out what we're doing with the statute of limitations issue. Number 10, this was to Ms. Jordan's point a few minutes ago about, did Ms. Jordan leave us? I think she did. In any event, she had mentioned the specific issue associated with evidence or inference that the city of Roswell will have to raise taxes or tax money and how that might affect, bundled with this issue of if we have, not if, I assume it would be a remarkable set of circumstances if we got 36 jurors on a panel and not a single one of them lived in Roswell. So I think now is probably the appropriate time to address that issue. Mr. Alderman?
Thank you. So I actually think these are definitely related. I actually think this motion in limine is a little bit easier to resolve than the qualification as a juror. But what we're trying to exclude is any argument, any kind of evidence that if a judgment is entered, then the city of Roswell will have to raise its taxes to pay that judgment. That seems to us to be just very straightforward black letter law that you can't talk about what would happen.
Let me interrupt you for 1 second, Mr. Alderman. Mr. Lael, do you plan to make that argument? Do you wish to reserve the right to be able to?
Well, I don't think we're going to make the argument that I think as Mr. Alderman put it, taxes will go up. I think there's certainly a possibility that the millage rate may be increased if a substantial award were imposed, but I'm not in a position to say at this point that taxes will go up, just that they may go up.
Okay, keep going, Mr. Alderman. I was going to see if we could cut that off,
Sure.
cut off that issue, but it seems like the city wants to be able to reserve the right, depending on the circumstances, to make that argument if they see fit. So I'll need to continue hearing the rest of your argument.
Right, thank you. So in the response from the city, what I saw was they want to be able to talk about the cost of providing these benefits. Well, of course, that's going to come out, and we're going to offer evidence. We have exhibits that are on our list that are going to show exactly why they chose not to give these firefighters benefits because of the cost and the analysis that they did and how much it would cost. We have all that.
Forgive me for interrupting again, but also, isn't the increased cost a closed universe at this point? Because hasn't the policy been amended to address, the policy manual has been amended to address this issue, has it not? Effective 2022?
The policy manual has been addressed to what the city would say, clarify what has been the case all along, whereas the plaintiffs say, oh, it's a substantial change, but.
Right, which I know is the subject of another motion in limine, so,
Right.
But they all tend to run together at some point. I'm sorry, Mr. Alderman, again, for the interruption. Go ahead.
No, that's fine. You're right, though. The issues that they say they want to be freed up to talk about are issues that are definitely coming in. So our motion is very narrow. It's just saying, don't make an argument that if there's a judgment, taxes will, or as Mr. Lael says, may have to be raised. That's not appropriate. That's not appropriate argument. That's not appropriate evidence. Instead, I mean, you can't talk about what someone would have to do or where the money to satisfy a judgment would come from. And that's all we're trying to exclude.
Mr. Lael, anything to add?
Again, I think this in some ways depends on the information that's presented to the jury. Some of the information that Mr. Alderman may be referring to actually breaks down the cost of going to a full-time department. So not the specific issue of the case of granting benefits, but going to a full-time department, and that calculation is then converted into mills in terms of what impact would that have on the millage rate. Now, again, whether that necessarily would mean that the elected body would choose to implement a tax change or not, I'm not going to speculate. I'm not going to speak for the elected body. But again, that's information that, again, that's a choice that may have to be made.
Now, when you talk about this concern that the model of, I assume there's some evidence in this case that the city has at some point, either as a result of this litigation or independently, considered the issue of changing to a full-time fire department instead of the model that it had adopted for the relevant class period.
They've actually adopted I'm sorry, go ahead.
No, please go ahead, Mr. Alderman.
Yeah, the city of Roswell has adopted a 5-year plan from 2022 through 2027 to move to a full-time staff fire department.
Okay. So my feeling is that, and this is, I think, a nebulous enough issue that it really is going to come down to how it's characterized. What I'm hearing from both of y'all is that evidence is likely going to come in, right? The fact that the city has to make decisions based on tax dollars that are available to it, those are issues that are going to be, you can't tell the story of this case without those issues. But that next sentence that for lawyers likely follows right behind it, which is, so that means, jury, if you rule against the city of Roswell taxpayers are going to pay this bill. That's a bridge further than I think needs to go. And so evidence about, assuming that I'm going to subsequently, when we deal with that issue, rule that the new full-time model that the city of Roswell has adopted is relevant to the issues in this case, and that it's going to come into evidence, I think that's fair game. But the out loud argument that means that the millage rate will go up, or that the citizens of Roswell will pay higher taxes, I think is off limits for now. That's going to be my ruling.
Thank you, Your Honor.
Thank you. Hang on. figure out where we left off.
I think we're on number 12.
Number 12, thank you. And this is voir dire as to class actions and potential bias as to the amount of a verdict that might be requested.
Exactly, Your Honor. You led off this hearing by talking about how this is an interesting case. So you've got people watching to learn from it because there are big dollars involved. And that's sort of what we're getting at here. If we have prospective jurors in the veneer who are opposed either to the idea of a class action or opposed to multi-million-dollar verdicts out of hand, that's something that we need to know about, and we need to exclude those jurors. So in order to figure that out, we need the ability to ask those questions. And that's all that we're seeking to do. We've cited the Atlanta Joint Terminals case. We do acknowledge that it's physical precedent only. We did that in our brief, but it's also been cited positively by the Supreme Court for that precise issue.
Okay. Mr. Lael?
I think the concern we have, and this kind of dovetails, Your Honor, with our fourth motion in limine, with kind of aspersions about a bad faith motive on the city's part without linking it to any specific evidence. I think if in voir dire, the plaintiff's counsel were allowed to say, we think we're going to be able to show blah, blah, blah. Does anybody have a problem with that? Does anybody have a problem with X $1 million, granting a relief in that sort of amount? I think that would be very prejudicial because it would set the stage that, wow, this is a big dollar case. And at that point, nobody's heard any evidence. Nobody's seen any exhibits, nothing at all going on. And the cases cited by the plaintiffs involved voir dire questions with specific dollar amounts. And that's what we want to avoid. We came across one case in doing our research that said, does any panel member have reservations about awarding a very large amount of money if justified under the evidence? I think I'd be okay with that. But if they're going to say, all right, if you put our attorney's fees claim together with the maximum possible recovery for the class, and that gets to this many million, okay, does anybody have a problem entering judgment for that many millions of dollars? I think that plants a seed in the juror's mind that this is a big dollar case. And hey, if they cut that in half or fourth or whatever at the time of rendering a verdict, assuming they render a verdict for the plaintiff, they may think, gosh, we've done the city a favor. So what we want to avoid is placing that kind of super high amount to begin with. And that just leaves an awful lot of room that, again, a jury might think that they're being reasonable by awarding much less and not necessarily acting just on the basis of the evidence.
Okay, Mr. Alderman, your motion, you get the last word, sir.
Thank you, Art. I've not heard that exact take on this argument, probably because those numbers are going to come in. We're going to introduce evidence of what our expert says as the total amount that should have been paid. We're going to offer evidence of attorney's fees. We may do it as soon as, I don't know what we're going to say in our opening, but it's common for attorneys at the beginning of the case to tell the jury what they're going to ask for. So, and that's perfectly appropriate. Just like it would be perfectly appropriate to ask them, the jury panel, before they get selected, if they have some bias that prevents them from being fair about awarding that amount.
Okay. So I think there's a couple of things. One, I'm not hearing anybody make any argument about the idea of a class action, even though that is also part of the motion in limine. And so to be clear, it's absolutely fair game for both sides to ask the jury if they have strong opinions about, whatever variation of that question y'all end up framing it, however you frame it. If they have strong opinions about class actions, right? I mean, clearly that's fair game. As to the issue of large judgments, I think it really comes down to how the question is framed. I think that the idea of whether juries have strong opinions, again, however you choose to frame it, about large verdicts is absolutely a fair matter for the lawyers to inquire into. But I think that there is case law that characterizes as problematic the effort to sort of pre-try the case during voir dire, the effort to inject specific dollar amounts that will later be asked for in the context of extracting a promise that they wouldn't discount that immediately. That's the case law I'm familiar with. And so I would be concerned about, even if the first thing Mr. Somerville says, assuming he's doing the opening when he stands up, says, I'm going to ask you for $80 billion, right? That's still the first appropriate time, to my way of thinking, to talk about a specific dollar amount that's at issue. Now, that the dollar amount might be a large amount of money, I think is fair to inquire if the jurors have strong opinions about large verdicts or runaway verdicts or whatever we want to call those things. And I think that's fair, and I'm not going to limit anybody's ability. But I am going to limit the plaintiff's ability to specifically ask jurors about a specific dollar amount that they intend to ask for, or would you not award something over $1 million or whatever. But I think we should stay away from dollar amounts. That's going to be my ruling. Okay.
Thank you.
Okay, and then that moves us on to number 13, the city's human resources policy, and it not being a binding contract.
Thank you, Your Honor. I heard you say something earlier that made me concerned about this motion, so you may set me straight. I read your summary judgment order to say that the policy manual is a binding contract on city employees. When you talked earlier about expecting evidence about the disclaimer, I thought maybe you know what your ruling was better than I do. But to the extent that this motion was filed because I interpreted your summary judgment order to say the policy manual is a binding contract. And if that was your order, then the city should not be allowed to argue at trial that it's not. That's as simple as this motion is.
No, and I think that's a fair characterization of what your understanding of my ruling and everything else. What I said before, and I still stand by it, is that the language that I use there, I tried to be very careful with it, because to my way of thinking, the issue is who are parties to that contract, right? Like I'm embarrassed. My teenagers would be yelling at me that they just heard me say "like" twice in the same breath. In any event, to my way of thinking, the policy manual and all of its glory and flaws, it's coming in. How Roswell framed it and the fact that Roswell included a disclaimer is relevant information. And I expected that I would hear the city make an argument that as to these employees or as to all employees, it's not a contract. It's not a binding contract. Having said that, my point in summary judgment, whether it was inartfully crafted or not, was that the contract is or may be, the policy manual is or may be a contract, subject to whether or not the terms are ambiguous and to whom those terms and that contract applies. It had not been my intention to exclude the city's ability to try and argue that there was a disclaimer of any benefits to their employees.
So I'm pretty sure I understand what you're saying. Is that to your mind, you have not decided with respect to any employee whether the policy manual is a contract. The reason it's weird for me to be asking you, but the reason we filed this motion is because we thought you had decided that. But if you haven't, then I'm not going to ask you to preclude evidence if you haven't decided that.
So I think the issue is, and then I'll hear from Mr. Lael. So the point of what I was saying in the summary judgment motion in that point is that, to my way of thinking, there were two issues. And One is the parties were asking me to determine that there absolutely was a contract and it absolutely was enforceable as to these employees. And my point was all that issue is wide open. However, what I'm not going to listen to the city say is that because there was a disclaimer, there was no contract as a matter of law. And because the city could change the policy manual anytime it wanted to, there was no contract as a matter of law. That's not the same as saying there is a contract as a matter of law, or that the disclaimer and the fact that the city can amend their rules as a matter of law meant the inverse was also true. I fear I may have said that inartfully, but it was my expectation that the fact that the city could amend and the fact that the city included disclaimer language did not defeat the fact of a contract, but not as a matter of law.
Okay. Given that, I don't have any further argument to make on that motion.
Mr. Lau?
No, I think that our whole point is that, we wanted to be able to argue some of the issues that you've just identified, which is, who is eligible for benefits under the terms of the policy manual and all the terms of the policy manual. So I think we're in alignment.
Okay. So 13 is going to be denied. And I think that leaves
14.
14.
Yes, Your Honor.
Which goes straight to the heart of what this case is really about, which is, what do all those words mean in that contract?
What we're trying to exclude here is only parole evidence about the clear portions of this policy manual. And so we don't think there should be any parole evidence offered to explain the two sentences that are quoted on page 15 of our motion, which is an employee whose standard work week is 40 hours or more is a regular full-time employee, and an employee whose standard work week is less than 40 hours per week is a part-time employee. Parole evidence, such as the city's subjective view as to what that means, we think is irrelevant because this is plain and unambiguous. Now, there are other provisions of the policy manual and other documents they try to incorporate by reference, and they make arguments about those, and those are ambiguous, and parole evidence can be admitted on those from our perspective, but on portions of the document that are clear and unambiguous, there shouldn't be parole evidence offered to interpret those provisions.
Okay, Mr. Lael?
Your Honor, we in our response, we kind of dealt with 13 and 14 together, and I think the same rationale applies to this issue as the court just pointed out a moment ago. Whether there's a contract is wide open, and so I guess we take issue with the plaintiff's characterization that there's any clear and unambiguous language in the policy manual at this stage, with summary judgment having been denied. Of course, we took the position in summary judgment that it was clear, and it foreclosed the plaintiffs being among those who are eligible for benefits. But in light of the court's summary judgment ruling, it seems to me that everything is kind of open and subject to parole evidence and an explanation.
So I agree with the city that the terms of the contract and who was a full-time employee, who was a regular full-time employee, who was a part-time employee, and what was a standard work week. Part of what defeated the city's effort at summary judgment, to my way of thinking, was the fact that those terms are used in various places in various iterations of the policy manual in ways that could be interpreted differently. And so if in fact they were clear and unambiguous, I would agree with you, Mr. Alderman, but I think they are ambiguous. And as a result of that, what the parties understood them to mean and other associated and relevant documents and et cetera, containing those terms and what they meant, are admissible. So motion limiting number 14 is going to be denied.
Thank you.
Okay, I think that takes care of the plaintiff's motions, I should say. And so we'll move on to the city of Roswell's. Mr. Lael?
Okay.
Were there
So-
some that the parties had worked out agreement on? And if you could run through those numbers for me?
Yeah, unfortunately not on our list. They were not able to reach any sort of common ground on any of these issues. So I'm afraid all 5 of our topics are open for discussion unless I think based on the court's ruling about the Rogers and Burnett situation, I think that actually does take care of topic number 3, unless I misheard the court's ruling from before.
No, that was my intention, is that if, I think that the issue with Chief Burnett, which is, let me get to it.
It's topic 3 of our motion, but it was
Thank you.
topic 2 of the plaintiff's motion with respect to Rogers.
Right. What I was trying to get to and finding it in your motion is that topic 3, I think, is less directly relevant than would be potentially Mr. Rogers, but that in terms of all things being equal, I think what I had said was that the parties can and should agree on a way to characterize Mr. Rogers' separation from the city. And that once that occurs, then neither Chief Burnett's prior issue nor Mr. Rogers' prior issue would be relevant on its face. So that would mean that I would be granting item number 3 of the cities and had already granted the plaintiff's motion regarding Mr. Rogers.
Yara, can I be heard briefly on item number 3?
Sure.
Which is of defendant's motion. We tried to parse out what they may be trying to exclude. And certainly we agreed and said so in our response that we can't introduce extrinsic evidence of this diploma, which we don't have, the fake diploma, and don't want to, but and the court has discretion, certainly, and it sounds like you have already decided, I'm sure you've already decided, that we shouldn't inquire on cross-examination about this scenario with his credentials. But that still leaves open 608A testimony from another witness about his character for truthfulness or untruthfulness. And I think that is still fair game if he in fact testifies.
Okay. That's a different issue. I agree with you that my intention was that the parties not delve into the topic at all, right? So that the ruling in limine that this issue associated with Chief Burnett's prior diploma and the issue associated with Mr. Rogers, the basis for Mr. Rogers' termination, that they were not relevant and therefore they shouldn't be inquired into. And by extension, that would potentially also include the right of the plaintiff to attempt to elicit testimony from another witness using this particular circumstance as evidence of a character for untruthfulness.
Okay. So my understanding of Rule 608A is that a witness can testify about the character reputation, which certainly the chief of fire would have had around the fire department about a reputation or character for truthfulness or untruthfulness. But they can't say, for example, Mr. Burnett lied in 1995 when he said he had a high school diploma, or he lied when he said he had passed the GED. That testimony would be inadmissible.
That's correct.
But testimony about his general reputation or an opinion of his reputation, I believe, is admissible under 608A, as long as he takes the stand and testifies.
I think you and I are saying the same thing, but
Okay.
it's just as well that you ask for clarification to make sure that we're on the same page. My point is that to the extent that anyone intends or wants to use that specific instance, my ruling is that absent a specific set of circumstances, right, that evidence would not be admissible and therefore it should not be inquired into. That's different than asking a witness about their general character for truthfulness or untruthfulness, except to the extent that the next logical discussion of that issue potentially are specific acts of untruthfulness, which you've already characterized as to how that would be appropriate or not appropriate. So that was my issue, is let's not raise it if we don't have to.
Got it. Thank you.
Thank you. Okay, Mr. Lael, let's go back to number 1
Okay.
from the city regarding the policies and practices subsequent to the class period, which I am given to understand now specifically relate to changes that the city either has made or has adopted and not yet implemented regarding its fire service and changes to its policy manual as a result of that.
That's right. So as we've been discussing under several headings of our conference today, the class period is set as August 2011 to August 2017. That's the 6-year period during which these firefighters claim entitlement to certain benefits. And so as we had discussion earlier, we're looking at a policy manual first adopted in 2002, and then changes in that kind of up through the middle of the class period. Then we're looking at the 2014 policy manual to the end of the class period. And what we're trying to do here is just head off any effort by the plaintiffs to introduce post-class period issues, because they're irrelevant to whether under the language of the policy manual in the first half of the class or the second half of the class would entitle these or make these part-time firefighters eligible for benefits. And in fact, we raised 3 rules and 3 kind of concepts under this topic. The first is 401, just general relevance. And I don't see that the plaintiffs really directly address that issue in their response. And the fact that there was different language in the policy manual in 2022 does not mean that the city interpreted the class period policy manuals any differently. It's just, again, different language for the same concept. And at that time, they're also different council members. They're different to the extent that there's an effort to show bad faith. First, this is well after the litigation commenced, and they're different decision makers at that point. So I think that relevance issue has not really been addressed by the plaintiffs, but certainly things that happened 4 and 5 years after the close of the class period don't really bear any helpful input on the issues in the case, which is whether they were entitled to benefits at that time. Then there's also the risk of confusion under Rule 403 that, again, if this evidence comes in, there could be a conclusion reached that, well, because they changed it must mean they thought it was wrong before. And while we could address those things with our own evidence in response, that becomes then a mini trial on the new issues that are, again, 4 and 5 years after the class period itself. And again, that just seems to sort of waste time for getting into or covering the issues we have in the 3 to 4 days that we've allotted. I'll also address that in the response brief from the plaintiffs, they identify part of the strategic plan that the current fire chief, who was not there during the class period, has put in place, and making a claim that it shows that full-time employees were in fact paid more than what the part-time employees were paid. But the chart that they point to includes the full salary and benefits of 21 positions. There's not an individualized breakdown of what the actual rate of pay for anybody is. So I would say that's not an apples to oranges comparison. And then they also want to address the staffing model change, but again, that would get into a little bit of a mini trial where they say the old model is basically the new model. It is not. The old model had 30 plus part-time captains that were filling in slots in these various stations, whereas now there are 21 specific fire captains who are regular full-time positions, and they work an ABC schedule, 24 hours on, 48 hours off. It's the same captain on every A day, B day, C day. That's how you know who's who, whereas under the old model, depending on a part-time firefighter's stated availability and how the city scheduled them, you're never quite sure who's going to be the captain on this particular shift in this particular station. It varied a lot. And then I would say that the subsequent remedial measure issue under Rule 407, I think these changes do amount to subsequent remedial measures to clarify, not to correct, but I think this was a clarification. And I'll point out that the one case cited in that section of plaintiff's response, Sicily, actually excluded evidence of aircraft changes under Rule 407, but said that they might be admissible for other purposes, such as impeachment, if some of those changes sort of came up in somebody's testimony. So I think for all those reasons, this motion should be granted.
Okay, thank you, Mr. Lael. Mr. Alderman?
Thank you, Your Honor. As far as relevance goes here, this is admittedly easier after your prior ruling on the contract being completely up in the air. If we're going to talk about parole evidence, we should be able to talk about parole evidence. And one of the things that we contend that happened in this case is that the city said one thing and did another. They said they were part-time, but they actually treated them as full-time workers by scheduling them full-time hours, paying them overtime in a variety of ways. They treated them as full-time workers. And what these prior, particularly the new plan in place shows is that really they're just now calling them what they were all along, which is full-time employees. The fact that they've made these changes to the policy manual, the fact that they've implemented this new staffing model is also admissible evidence to show feasibility and control that they could have done something differently.
Well, nobody questions that they had the authority and control, but I'll go with you for a minute that it might be relevant to the feasibility of having a different model.
Right. So, sorry, the subsequent remedial measure argument, I do not, this is not a subsequent remedial measure. That rule is intended to exclude relevant evidence, which is a tacit admission that this is relevant evidence, but it's a rule to exclude relevant evidence for the purpose of making people safer. And a contract revision is not a subsequent remedial measure. No one is safer because of it. It doesn't protect against the harm that the firefighters have suffered in this case. And that's what the subsequent remedial measure rule is intended to do. That's just, it's almost a red herring, but I want to mention it because it was argued in the brief and Mr. Lael argued it as well. But all of these, and I think these are the two things. It's the 2022 contract revision and it's the 5-year plan. I think those are the two things that this motion seeks to exclude. And both of those are relevant to how the city treated the firefighters and what they thought, both through the contract language that existed at the time versus how they've changed it. And then secondly, the fact that they are now doing and saying the same thing, whereas during this class period, they were doing one thing, saying another.
Okay, Mr. Lael, your motion, you get the last word.
Thank you, Your Honor. I think from you've indicated a preference for practical considerations. And I think here practically, if we had a mini trial on the new staffing model, we'd have to potentially parade a whole additional set of witnesses in on this issue to address this much later issue than anything during the class period. And also, I think the 407 argument just doesn't hold water. We cited a case in our response that dealt with a promotion and a manager's comment that, well, we changed it so that people wouldn't feel overlooked or feel discriminated against. That's not a safety measure, and that was a 407 case. So this is not limited to safety considerations. That's one of the reasons, but it's not the exclusive reason for applying Rule 407. So again, I think this would complicate the trial unnecessarily and would get into irrelevant evidence that just isn't going to help the jury determine the true issues of entitlement during the class period.
Okay. I'm going to deny the motion. I think that Mr. Alderman, the sentence that he said that I think sums it up quite well is that if everything is on the table, then every iteration of the city's understanding of what terms like full-time employment, standard work week, 40 hours, all those things, and the city's use of those things in context is relevant. I understand the city's concern about the confusion of issues, but because once we deal with this second amended complaint and that issue, we do have a fairly clear class window, and I'm certain that the lawyers will reiterate to the jury that any ruling they make is going to be controlled by that time window. So to be clear, I do think that it is relevant evidence as to what the city's understanding and use of these terms are. I don't think that there is a substantial risk of confusion. I think that it could be characterized as a subsequent remedial measure, but that it could also still be relevant as to the feasibility of the city adopting a different model than that which it previously had. And so for that reason, I'm going to deny the city's first motion in limine regarding the 5-year plan and the subsequent 2022 policy manual. Now, having said that, I suspect that I may want to put some guardrails around how far into that we're going to go, and that perhaps we'll have a conversation about that once you guys have had some time to meet and confer about what witnesses you really are going to call, what documents you really are going to use, that sort of thing. And we may have a conversation about that because, to Mr. Lale's point, I don't want to have a mini trial all about the new plan and what it means. But to the extent that there are terms that are consistently or inconsistently used across the iterations of this policy manual, I think that's relevant evidence and that we should hear about it. So that is going to be denied.
And Your Honor, if it's all right, we like a little bit of latitude to amend our witness list just for this issue, if this is something that's going to be tried, because we'll need to consider who can best address some of those later changes.
Okay, and I will hear any argument. I think that's a fair request, and I'll hear any argument or objection to that as it comes up. But of course, I would just say that to the extent that you do identify a new witness, it needs to be very clearly in service of this particular issue.
Sure.
Okay. Item number 2.
Yes, Your Honor. This has to do with the experts' calculation of benefits using a supposed full-time rate. So just for background, what the plaintiff's expert did is he prepared a big spreadsheet that showed here's the PTO calculation, the sick leave calculation, this, and this, using the actual historical pay rates during the class period. And then he did all that again using what he deemed to be a full-time rate for all of the various class members, because he said they would have been paid more. Now, when I asked him about that as an actuary, I said, is there an actuarial basis for this determination? And he said, no. I said, well, could there be an actuarial basis for it? And he said, well, I would need to know this, and this category. But even then, I'm not even sure I could do it. So from an actuarial standpoint, it's not supported. From a contract perspective, the plaintiffs have articulated and identified parts of the policy manuals that give them a basis to say, hey, we didn't get PTO, we didn't get sick leave, we didn't get LTD coverage, but they've pointed to nothing in the policy manual that indicates that they would get a higher or different rate as full-timers than what they got as part-timers.
Well, let me ask you, because this is, obviously we dealt with this issue on, some Daubert motions. We talked about these. And of course, my position then was this goes to the weight and credibility to be afforded to the expert's opinion. I understand we're procedurally postured in a different place in terms of the scope and scale of that testimony, which I think I referenced when I was ruling on that Daubert motion. But one of the things that I still think I don't fully grasp is if the case is not about pay, right? If the case is not about, I think I agree as an initial matter, tentatively, with the idea from the city that there's not really evidence in the case that the city paid more to people who were characterized as full-time employees as opposed to those part-timers who were allegedly working way more than 40 plus hours a week. If it's not about that, then why would this witness be testifying about that anyway? Is it because it results in a higher benefit to that individual? Is that the reason that it's here?
One could surmise that.
Okay.
Because there's not really another good explanation. What the expert did is he took information from two different pay studies and said, okay, in 2014, here's the median, and in 2020, or maybe 21, here's the median. And so I'm extrapolating to figure out in those years in between what their pay would have been to put them at the median. But there's record evidence showing that the city chose pay rates that they knew were less than the median. So you begin with the knowledge that a median necessarily means half the employers paid less than the median. And you also get into the specifics of the city's pay raises in light of the pay studies. And the testimony was that we take the pay studies as a factor, but we also use our judgment in terms of what we need to pay to get people into these positions. And so sometimes we pay less than the median. So there's evidence in the record showing that the rates for various part-time firefighting positions were like 80th, 82% of the median, sometimes even less than that of the median, depending on what the information is. And there's also evidence we pointed out in our brief that in reaching what the median figure was, the plaintiff's expert actually used a miscalculation of the information to arrive at I think a $24 an hour median when actually it would have been, 18 something. Again, it's in the brief. So I think it's the risk of confusion here is that he's an expert, he's an actuary. Some jurors may not have even heard what an actuary is. And so they might think, oh, he's a really smart guy with numbers, he must be right. And we want to avoid that kind of misimpression in light of the sort of wobbly foundation for this calculation in his own report and in his own testimony. And I would also raise that in the original complaint, there was no plea for a differential or any allegation that part-time pay was inadequate. And the first amended complaint does not independently allege that kind of claim. In fact, it only says that it had already been raised in the original complaint, which we contest. So I would say that even now, the plaintiffs haven't made an independent claim for a pay differential in their pleadings.
Okay, thank you. Mr. Alderman?
Thank you, Your Honor. A couple of things. First, this is just a Daubert motion and it's already been denied. Large chunks of this were cut and paste from the Daubert motion. And you did reserve ruling on part of that Daubert motion, but it was the credited service calculation part of that ruling, which this isn't. And the way I read your ruling is that these types of critiques or ideas that he made the wrong assumption are things for cross-examination, but they're not to exclude his testimony either entirely or on a particular subject. But this is fundamentally not the time to raise a Dauber challenge. The time has passed, but they did raise it and you denied it. And that's one thing. Another thing is that there is evidence that the city pays full-time workers more than they pay part-time workers. There's everyday walking around knowledge that full-time workers are generally paid more than part-time workers. And there are assumptions.
Well, forgive me for interrupting, but help me understand what you mean when you say that, because if you're paid on an hourly basis and everybody makes $20 an hour, I know that's not the case here. I'm oversimplifying it wildly, but it would be what you just said would be correct, that everybody understands that full-time makes more than part-time, but it's because they work more hours. That's not the same as saying that somebody who is employed as a full-time employee makes $22 an hour and somebody who's a part-time employee only makes $18 an hour. And what I mentioned when I was asking Mr. Lael that I don't grasp is, number one, what is the nature of the argument you're making about that pay differential? And number two, is that issue here? Because as I read the claims that the firefighters have made, it has not, I didn't understand it to be for pay that was due to them, but for benefits due to them that it admittedly may be affected by the amount of pay they earn. And so 2 questions, all of that was a long way of saying. One is, am I correct that that's the plaintiff's position for why this matter, why the information about a pay differential would be relevant? It's not because they're seeking damages for lost pay or less pay, but because it affects the amount of benefit they might be entitled to, number one. And number two, in terms of the less pay model, are you arguing that they actually made less in terms of what the city paid on an hourly or salaried basis to someone who was part-time or full-time? Or are you arguing that as a function of the number of hours they worked, they made less or more?
I always do this, and I hope it's not a problem. I always start at the back because that's the freshest question on my mind.
Totally fine.
It's not the pay difference here is not based on working less hours. There's what Mr. Lowell will testify to is that had they been classified as full-time employees, as they actually worked full-time hours, they would have been paid more. And he has several reasons that he would say that. One is as simple as it costs employers more to replace a full-time worker than a part-time worker. So he can make an actuarial assumption that a full-time worker would be paid more. We also have evidence of these pay scales from across the city where there are different and higher rates for full-time employees than part-time employees. Not these firefighters, because none of them were classified as full-time employees. So that rate doesn't exist. So he's made these assumptions. And there's also evidence based on this new model that's been adopted that the pay scale is higher for these full-time employees than for the part-time employees. That's the evidence to support his assumptions.
Okay.
And then there's really, unfortunately, 2 answers to your question about the nature of this. It does make a difference as to the benefits available. It also makes a difference as to the amount of money they would have been paid.
Okay. But let me go back. I understand it makes a difference as to the amount of money they would have been paid, but that's relevant to this case because it affects the amount of benefits to which they might have been entitled, correct?
That's correct.
Okay. Okay. Anything else, Mr. Lael?
No, I don't think so on that. I think some of the information or explanation he attributed to Mr. Lowell, I don't remember off the top of my head, having heard before, but I don't have his deposition here to cite chapter and verse.
Well, even if the words are not coming directly from Mr. Lowell's report, Certainly they are all intertwined, and experts are allowed to rely on opinions of other experts. Well, I mean, they're allowed to rely on facts, et cetera. Here's what I'm going to say. What I'm going to say is this. I've already ruled on the motion, the Daubert motion regarding this witness. And I've ruled that most of what the city has asserted in terms of deficiencies in his opinion and anticipated testimony were subject to cross-examination and went to the weight and credibility that would be given to his testimony rather than to its admissibility. I stand by that. To the extent that originally I had a concern about the relevance of some of the testimony, I think that plaintiff has addressed that concern, at least for a basic proffer of the evidence, of why that evidence would be relevant to the issues in the case. And so for now, I am going to deny the city's motion limiting number 2 regarding Lowell's opinions and his testimony regarding the hypothetical full-time pay and its effect on the potential benefits that those employees might have realized. I've already ruled on number 3 from the city, so we could move on to number 5. I'm sorry, number 4.
4, yes.
Yeah, I went to law school, not math school. I can't even count apparently. So. Okay, number 4, the city's alleged motive in having a part-time staffing model. So let me start by saying this. Apparently that issue is going to be front and center given Ms. Jordan's statement at the beginning of the hearing regarding some, according to her, problematic statements made by the mayor at the time. So with that out there, go ahead, Mr. Lael.
Well, I think maybe some clarification is in order in light of the response from the plaintiffs saying we're not quite sure what they're looking for. I think this it's somewhat comparable to the plaintiff's motion in limine that we agreed to with respect to using terms like playing the lottery and plaintiffs getting a windfall. In the original complaint, the plaintiffs alleged that there were budget cuts wrongfully taken out of the pockets of deserving firefighters. And in the first amended complaint, they claimed that the city engaged in a concerted effort to devalue the work of part-time firefighters. These are color words and characterization words. And just like we're agreeing not to use things like playing the lottery and windfall with respect to their seeking damages in the case, we think that they're using those sort of characterizations or color words should also be barred. Now, if they want to introduce actual evidence that supports the notion that there was some underlying plan or scheme or whatever, as Mr. Alderman has said today a couple of times, they said one thing and did another. If they want to introduce evidence about that, okay, that's their case. We're not taking issue with that. But the concern I have is that they get up in opening statements and talk about having the city having devalued the firefighters or these other color words. I think would be just as damaging as our using terms like they're playing the lottery, they're trying to get a windfall. So as Your Honor said earlier in the conference, what's good for the goose is good for the gander. It seems like that ought to play in this particular topic for us.
Okay, Mr. Alderman.
Thank you, Your Honor. Starting again with the last thing I heard, there's a big difference between the lottery and windfall arguments that are really critiques of the justice system and critiques made of the actions of the parties in the case. What we are going to attempt to prove at trial is that the city not only denied benefits that the firefighters were entitled to, but they did so in bad faith. And so we do intend to put on evidence of that. I've foreshadowed this earlier. A lot of it has to do with an attempt to save money. And they told the firefighters one thing, they treated them a different way. We have evidence that will support what we're saying. but we're not only allowed to offer that evidence, but then we get to characterize it in argument as well. So we have a 13-611 claim, and in order to win on that, we have to show they acted in bad faith. What I view, the last motion we discussed was really a Daubert motion. This is really a summary judgment motion on our 13-611 claim, seeking to preclude us from offering any evidence about the bad faith of the city in this case. And maybe it's not directed to the evidence, but it's directed to characterizing the evidence. But certainly if we put on the evidence, then we get to characterize it, and we certainly get to preview it in our opening statement. But there's no claim we have, or a lot of what they've argued in their motion is motive isn't relevant to breach. And that's not what we're arguing. We're arguing that motive and intent is relevant to their bad faith, which we are entitled to put on evidence as to that.
Okay. Mr. Lael, anything to add?
Well, I'm not sure that, again, the idea that they can just get up and say these things without having evidence to back it up. I understand what Mr. Alderman is saying, that we do have the evidence to back it up. I'm not entirely certain what that's going to be. But again, just as using windfall or whatever might be, problematic for the justice system, I think also trying to prove bad faith by lawyer comments also is not good for the justice system. So I think at least an opening statement that they preview the evidence and not characterize it. Now, once they've got evidence in the record, in the closing argument, if they want to try to characterize what they've got, well, okay. And we can try to characterize what they've shown in evidence as well. But I think what I'm trying to avoid, just like with the voir dire question about a certain dollar amount, is getting the jury somewhat inflamed with character words or color words that may or may not be supported later by specific evidence.
Okay. So to me, this issue is very similar to the one we talked earlier about whether the taxes are going to go up. I absolutely agree that if the plaintiffs have evidence that they will offer that there was a reason that is obvious, can be inferred, or was outright stated by the city in adopting the model that it adopted, that's fair game. But I also think that it perhaps is a bridge too far in terms of argumentativeness in an opening statement. And that one way to solve this issue is to say, I'm not going to say that you can't offer, if you have evidence, and it sounds like you believe that you do, problematic statements or actions taken by the city that imply, or from which one could infer, a negative motivation against firefighters or whatever. And then from there, perhaps you can make that argument in closing, but I think it would be off limits in opening until after such evidence has been introduced. And to be clear, I don't mean to imply that you can't talk in opening about evidence that you believe you will offer. But on this particular issue, I want you to stay away from it because I think it is highly argumentative. And let's remember that our openings are supposed to be a preview of the evidence you believe you can offer, not an argument about what that evidence means.
May I interject a question here?
Sure.
And I know Your Honor doesn't love tag teams and stuff like that, but I'm probably going to do the opening. And so if I say, look, one of our claims is for bad faith. Now, bad faith under Georgia law, the judge is going to instruct you is a malevolent motive, bad faith motive, whatever the charge is, right?
Right.
Or the case law is. And we intend on presenting evidence that the city did X. They qualified these gentlemen and ladies as part-time when they were really working full-time, so that way they wouldn't be on the city's dime. No, I don't think there's any color words, whatever those are.
Those are, to my ear, Mr. Somerville, those are facts.
Okay,
assuming
exactly.
that you
That's-
have evidence that you believe you will be able to offer.
Sure. I mean, we're not, yeah, I would be incredibly foolish if I said something we're going to show and then get tagged for it later. So I don't plan on doing that. So
I understand Mr. Lale's comment, that the purpose of the motion, and correct me if I'm wrong, Mr. Lale, but based on the motion as it was presented in writing and as you've argued it now, it really is about the language that is used to make those arguments. And that's what I am cautioning you to stay away from. That, you know, what you have just characterized, I think those are, I believe that I'm going to be able to offer into evidence facts that will show you that they did this, this, and this for this reason. That's not the same as saying specifically to screw the firefighters to the wall, right?
I probably would not have chosen that phraseology to begin with. So,
Well, that's why I did it, because I felt like it was pretty over the top. So
okay, fair enough.
in
So,
any
thank you.
event, so I think that to the extent that item number 4 from the city, I think is twofold. The way it actually reads is asking me to prohibit the plaintiff from getting into evidence it believes will demonstrate a motive by the city. I'm going to deny that motion. However, to the extent that the purpose that the other concern the city has is this characterization of wrongfully taking funds out of the pockets of the firefighters, concerted effort to devalue the work of the firefighters, that language that the city has specifically referred to that's in the complaint, I am going to grant the motion to that extent, particularly as it relates to the opening, and then we'll play it by ear as we see the evidence come in and get to what the closing looks like.
Very good. Thank you.
Thank you, Your Honor.
Okay, and number 5, before we get into the substance of the attorney's fees, and forgive me if we've already spoken about this, but I know your verdict form is not due yet, but what are the parties' thoughts about what you're going to ask the jury to decide relative to the attorney's fees? Because as of course, all of you know, there are about 1 million ways to do that. You can present it in interrogatory form and ask the jury, do you believe there's entitlement? And then have me determine, assuming there is entitlement, have me determine the amount. Or you can present the amount and have the jury determine that just as a matter of damages, just like they would any other type of damages. The only reason sometimes people hesitate on that is that it always presents that weird awkwardness of one of the lawyers having to take the stand and be cross-examined by another one of the lawyers. Before we start talking about the substance of how you might prove that up, I'm curious, what exactly are you anticipating, or have you thought that far ahead yet about what you might be asking the jury to decide? If it will just be entitlement, or will you be presenting evidence of the dollar amount as well?
Well, from our perspective, when I would say we have not made complete decisions on all of those issues. When we responded to this motion, the only basis for us needing to talk about the fact that there was an appeal, the fact that there were 750,000 pages produced in discovery, would be to justify the attorney's fees.
Mm-hmm.
So to the extent there was some, one thing we talked about when we met and conferred was maybe there's a way that we stipulate as to what's the reasonable attorney's fees. We weren't able to reach that stipulation. Maybe we can later. But you're right. There are a variety of ways we could avoid having to do that. But to the extent that we need to convince the jury that the attorney's fees we present should be awarded, that's the only reason we need to get into this, and the only reason we intend to. But unfortunately, I don't think we have a final answer. To answer your question directly, we've definitely thought about it, but with counsel at 2 different firms, Ms. Jordan, who you mentioned, I meant to point this out. She's actually in Italy right now, so we've got.
Oh wow!
So that's why she probably dropped.
I'm jealous.
Yeah, me too.
I'm not sure I would have mentioned that. Okay.
Well, it's dinner hour in Italy. I just got back from Spain a few weeks ago, so it's dinner hour. So I hope she's having a lovely meal and some good wine. So
Yeah, so we've got, basically what I'm trying to say is we've got counsel all over the place and we haven't made an agreement. So I don't want to commit to you exactly how we've decided to do that because we haven't, unfortunately.
And the main reason that I mention it is I think that the issue of the city's appeals and those things that the city is asking to try and keep out, that the plaintiffs might want to raise those issues for two reasons. One is as to the dollar amount of attorney's fees if somebody determines that they're entitled to attorney's fees, right? Well, I had to incur all these fees because the city appealed. That's one issue. The second issue, and this to me, there's so much recent case law that I'm sure you guys have, delved into more recently than have I, but I am familiar that it exists and that I need to go and refamiliarize myself with it again, about what will constitute bad faith, stubborn litigiousness, et cetera, in the transaction and the extent to which that relates to the ongoing actual litigation. And so I mention that only to say this: if from a strategy perspective of how you want to present your case, if one way that we could dispense with that issue is for, if the plaintiffs do not feel it is a strategic disadvantage to them, to not have to present that matter to the jury, and because it wouldn't potentially be relevant to their argument for bad faith by the city, then you could simply proceed to asking the jury to decide, do you believe that the city has acted in bad faith, and that we would be entitled to attorney's fees. And then I could consider the amount of attorney's fees, et cetera, that are associated with that. That's the only reason I mention it. It may be that the plaintiffs decide that the fact that the city pursued an appeal goes to its stubborn litigiousness or bad faith, et cetera, and that needs to come in. And so I need to deal with this. But that's why I'm asking if the parties have thought of it in terms of how they're going to present that issue to the jury and what exactly you're going to ask the jury to decide on that issue.
Your Honor, without a stipulation or agreement, I think we have to present it to the jury because there are a lot of cases that say that has to be decided by the trier of fact. But if we can come to a different agreement, I actually don't know. Darren may. I don't know if we can come to a different agreement. I haven't seen a case on that. Darren may know.
Yeah. There are a couple ways we could do it, and Your Honor's touched on almost all of them. I mean, the question is bifurcation or not. Obviously, the jury is going to have to decide on the liability portion of the fee or the fee shift. I am virtually certain that we don't want to spend, a furtive 45 minutes with the jury on a Friday afternoon going, oh, let's put Mike on the stand and see how this goes, or anything like that. No offense, Mike. But the gist is, I think this is something that, given all of our various travels and the fact that Jen probably is, having a big old glass of red wine right now, that we probably need to talk about a little bit. But we hear your concerns. And we will do our very best with Pat and everyone to come up with a workable solution that does not extend the trial onerously, and gives us a fluid way of presenting it, if it's to the jury or otherwise. So
Okay.
That's our pledge.
Okay. So the reason I laid all that out is I do want to hear from the city, if you want me to, or we can put a pin in it until the parties look at how they might want to proceed, whether to bifurcate, whether to enter into a stipulation, et cetera. The relevance of the city's litigation tactics to the underlying claim. What do you think, Mr. Lael?
I think putting a pin in it is fine, and the parties can confer a little bit. I think the only point of the motion is that, the basis for a finding of bad faith is pre-litigation conduct, and therefore what we did strategically or just procedurally, whatever, in the case, shouldn't be the foundation for getting to liability. If they establish liability and then they get into how much are the attorney's fees going to be, then saying, yeah, there was an appeal, we had to respond to it, we had to show it for oral argument, that's fair game. But I think even then it should be, the reasonableness of the fees associated with those procedural steps, and not, characterizations of, well, they appealed and they lost, so they must have had, no good motive for again, I think just trying to limit that sort of statement or argument.
Okay.
Yeah, I mean, we don't disagree vociferously on this at all. I mean, I agree that bad faith is pre-litigation conduct, can be measured in during and post-event conduct. And I also completely acknowledge, which everyone seems to mess this up, that stubborn litigiousness and unnecessary trouble and expense have much better defenses than bad faith, frankly, bona fide controversy and such. So it may be one of those issues that becomes moot, depending on how the evidence plays out at trial. I am not confident talking today to tell you what I think is going to happen, but I know it will be something that Your Honor will probably confront a directed verdict motion on. But I agree that the notion of like, well, they appealed, it was completely frivolous, except we didn't move for frivolity fees or anything like that because they're $2,500. But that sort of thing. So I mean, we hear you absolutely, and I think we've all done this enough that we can get together and find a workable solution.
Okay. And so what I'm going to do is I'm going to reserve ruling on the city's motion number 5 until such time as the parties determine how they want to handle the presentation and decision making of attorney's fees, and the extent to which, and to be clear, my thought process is if the parties agree either to stipulate and let me decide, or if the parties agree to bifurcate, then presumably the city's motion number 5 is sort of obviated and I think made moot, because the jury doesn't need to hear about the fact that the city filed an appeal until after they make a determination that the city acted in bad faith and that attorney's fees are appropriate. And so that's what I was hoping the parties could figure out. And I suspect that once y'all are trying to put together a verdict form, proposed verdict form, et cetera, that y'all will be in a position to see what that looks like and how you want to approach it.
We will do so.
Okay. Anything else?
Not from defendant, no.
Nor from us, Your Honor.
Okay. Last thing I'll mention, I think I've mentioned this to y'all, but I'm not sure. I do my jury charges on a board, right? Like I do a PowerPoint presentation. So because all the studies tell us that people process differently, and reading a jury charge to jurors is like the most boring thing ever. And so at least this way they can read along with us as we're going. And so when you provide me with your proposed charges, to be clear, I do not need you to give me the text of any pattern charge that you suggest that I give, except to the extent that you believe it has to be tailored in some way. But if you're just asking me to give a pattern, then just say, give me the number, and it's going to go into my standard initial charge before we start the case, and then the standard pattern charges about credibility of witnesses and things like that. And then obviously to the extent that you give me, I expect I'll see a number of, non-pattern charges that are specific to the issues in this case, either because there are not pattern charges on some of these causes of action, which still boggles my mind, that some of these causes of action don't have patterns, or because you believe that any pattern is not appropriate and this is a specific set of circumstances that needs to be used. In the absence of a pattern, then I just need you to give me some case law, that shows that this is an appropriate statement of the law. Extra bonus points if you can show me where it's actually been used as a jury charge before. But the main thing I'm concerned about is, and this is just my particular bias that I start with, so I'm going to tell you where you need to start from. If you are going to ask me to reject a pattern and give something different, definitely come to me with lots and lots of authority about why I should depart from the standard or whatever pattern is applicable, because the case law and the best practice for judges is there are patterns for a reason. And if we're going to depart from them, there ought to be a valid legal basis for me to say, I am persuaded by this case law or by this person's position that I should depart from the pattern for this reason. So that's just my personal bias. Also, if you send it to me, please send it to me in Word format, because all that's going to happen is I'm going to copy and paste it into my PowerPoint. Bonus points if you want to send it to me in PowerPoint. Then I can just copy and paste the whole slide. But in any event, that is how it will go. I will provide you with a working copy of it, both by email after an initial pass at a jury charge conference. And then obviously once it becomes more final, I will email you the final charge that we all agree I intend to give, subject to objections. And I will also provide you with a physical copy that you can follow along with as I'm reading it. It will also be on the screens in your courtroom. Last thing, on your tables. Last thing is, I think all of you have taken advantage of, or either plan to take advantage of, an opportunity to make sure you're familiar with the technology in our courtroom. I use that term loosely. It's definitely not up to par. But what we have is, apparently Zoom will never go away. And so the way that we are currently sharing our evidence in Fulton County is through the use of what they call a Zoom room. So every day you will be provided, not on the day of jury selection, because we don't need it for jury selection, but every day that we are doing openings or providing evidence to the jury, we will have a Zoom session that is provided to you with a Zoom link, and you will log into it. And if you wish to share evidence, by putting it up on a screen, you can still blow it up and put it on an easel like I used to do, because I'm that old. But if you want to share it electronically, basically what you would do is pull it up on your screen and then share your screen in Zoom. Couple things to point out about that. One, I've learned from experience, although technically it's possible to only share two screens so that I can see it and the witness can see it, it's not workable. It's very clunky. And so to the extent that you have paper documents, you should fully anticipate and plan to have those paper documents in a form that they can be identified by a witness before they are published, so that the witness can look at it and say, yes, I identify this document. Now, much of that will likely be dispensed with, because you guys have done what I've asked, which is to try and agree on the documents that are just going to come in. To the extent, however, that you do need a witness to look at a document to identify it and to lay an appropriate foundation, my suggestion to you is that you do that in paper form and then have it electronically to throw up on the board, assuming it is admitted, and then permission to publish is granted. The second thing I will say about that issue is the jury does not typically have, I do have a computer that I can turn off Wi-Fi and give to them if you want me to give them a whole bunch of flash drives. But generally speaking, what goes back with the jury is still paper. And so as much as I would really like to have truly an electronic trial, to the extent that you want the jury to have those documents, you will need to plan to prepare for, notebooks or, stacks of paper labeled with exhibit numbers, et cetera, to actually go back to the jury for deliberation. Anything else?
Circling back real quickly, Your Honor, to the jury charge, do you give paper copies to the jury? And if so, how many?
I do. I give them one copy as a resource for them to discuss.
Okay. I
find that if you give all 12 of them copies, then they all turn into law professors who want to decide what terms mean what. So.
We've had an experience where somebody becomes the keeper of the charges, though. So
that's also true.
So much like some other law professors that we could probably share experiences about, they become the expert. So, okay, very good. Thank you.
Anything else, gentlemen? Okay.
No, thank you, Your Honor.
Well, thank you all for your time, for your preparedness. I look forward to the briefing on the issue of the second amended complaint. And we will be back in touch, I suspect, the end of that week, the 22nd, 23rd, in terms of whether we need to have a hearing or otherwise. Other than that, I will plan to see you guys on the 27th. Currently, that's the plan, on the 27th at 9:30. Okay.